Yes, Mr.
Lord, I think I was about to turn to, or invite you to turn to the MMI case. I wonder whether perhaps you'd be kind enough to do that. It's behind tab 20. Now, my Lord, you know from the very helpful introduction to the case that you were given by Mr. Edwards yesterday that this was a case in which there was a mismatch between the primary policy, which was on a continuous basis, and the 3 reinsurance slips, which were for specific periods of 12 months. My Lord, what I was going to invite your attention to, if I may, is just the provisions, both of the reinsurance and the underlying policy, just so that we can see how that works. And if you'd be good enough, please, to turn to using the red numbering in the bottom right hand of the page, page 383. You'll see there at the very beginning of his judgment, Lord Justice Hobhouse sets out the provisions of the slips. And you can see there that the period in relation to the particular slip that he's identified is 12 months at the 24th of June 1986. The interest is to cover legal liability. There's an insured limit of 2.5 million excess 500,000. The conditions are set out, and then conditions as underlying. And then he goes on to set out the provisions of the second and the third slip. A little bit down the first column of page 384, he then goes on to look at the contract of original insurance. And I'd be grateful, please, if you'd look about 6 or 7 lines down the first full paragraph. The sentence begins, the contract of original insurance underwritten by the plaintiffs and referred to in the slips was not of the same character. It was a policy whereby the plaintiffs undertook to insure the Port of Sunderland in successive years subject to the payment of annual premiums. The policy issued by the plaintiffs to the Port of Sunderland dated from before and continued after the 3 years covered by the reinsurance slips with which this action is concerned. And then, please, you can see the terms of the underlying policy. The insuring clause just at the bottom of the page, the company will indemnify the insured against all sums which the insured shall become liable to pay. And then, please, into the second column, there's a proviso having referred to accidental loss or damage caused to property not belonging to nor hired, leased or loaned to the insured. Then there's a proviso, the end of which says that whatsoever and arises during any period of insurance under this policy. Now, just for the moment, would invite you to underline the word arises, because one point that we may come to a little later might turn on that. So that then is the position so far as the policy is concerned. If then you'd be kind enough, please, to turn to page 385, at the bottom of the first column, you'll see the issue that Lord Justice Hobhouse identifies. He says that since the policy contemplated that it would be renewed annually, and since there was no annual limit on the liability of the plaintiffs under the policy, the date when a liability was incurred, provided that it preceded that the lapsing or cancellation of the policy, would not be material. The policy provider uses the phrase during any period of insurance under this policy, does not relieve the insured of the need to show that the loss or damage occurred whilst the plaintiffs were on risk, but recognises there may be successive periods of cover. And that is then distinguished by Lord Justice Hobhouse in the first full paragraph halfway down the page of the second column, where he says that, but the fact remains, the original policy issued by the plaintiff to the Port of Sunderland and the 3 reinsurance slips presented to and accepted by the reinsurance were not in all respects identical. The latter, and it's this language I would just invite your attention to, the latter were time contracts whereby the cover provided was defined inescapably by reference to the period of time, whereas the manner in which the plaintiffs and the Port chose in fact to conduct their relationship rendered in practice the distinction between the 1 year and another irrelevant. So, my lords, that is the distinction which Lord Justice Hobhouse draws, and which really that was the distinction at the heart of the case. And he really reinforces that point at page 387 in the first column at the bottom. And if you'd be good enough, please, to look about 6 lines down in the final paragraph, he says that the cover is defined by reference to physical loss or damage to property which arises during any period of insurance.
So I've lost
I've lost you.
Oh, I'm so sorry. It's the bottom of page 387. That's my fault. I do apologise.
Which column?
It's the first column, and down towards the bottom of the page, there's a paragraph beginning, nothing turns upon, and 6 or 7 lines down in that, the cover is defined by. It was just that which I was inviting your attention to. And then, please, if you'd be kind enough to turn to page 394, he addresses the approach of the judge, and he begins at the top of the first column of 394 by saying that, in my judgment, the judge's approach to the question of construction was radically flawed. And it was radically flawed because he didn't give effect to the time-related character of the reinsurance slips. And if one just goes down about 6 or 7 lines, in so doing, he clearly thought it right to disregard the fact that whereas the 3 reinsurance contracts were each distinct and independent contracts, under which the cover was defined by reference to the year of cover, the policy of original assurance between the plaintiffs and the court was by reason of its annual renewal, one to which the individual years of cover was not, as between those parties, material. And then, if you'd be kind enough, please, to look in the second column and the final paragraph on the right-hand side, he first of all introduces what was incumbent upon the judge, and then he says, applying the wording of the original policy to each reinsurance contract, it is necessary to ask whether or not the relevant physical loss or damage arose during the relevant period of cover. The judge came to the surprising conclusion that each reinsurance contract covered liability in respect of physical loss or damage, whether or not it occurred during the period covered. And then he goes on to say that by the reinsurance contract, and he went on expressly to contemplate the same liability for the same physical loss or damage might be covered under a number of separate contracts of reinsurance. And he pauses and then observes that this is a startling result, and I'm unaware of no justification for it. When the relevant cover is placed on a time basis, and these are critical words that we submit, that the stated period of time is fundamental and must be given effect. And then he sets out what the commercial basis for that is. He says it is for that period of risk that the premium payable is assessed. That this is so whether the cover is defined, as in the present case, by reference to when the physical loss or damage occurred, or by reference to when a liability was incurred or a claim made. And then a few lines further down, it provides a temporal limit to the cover and does not provide cover outside the risk. The insurer is then not on risk. And my Lord, that's the point I started with the simple approach to the construction of the insuring clause. It is only damage during, it's not damage outside. And in a paragraph just beneath the one that I've invited your attention to just now, beginning, I should mention that, what Lord Justice Hobhouse does is anticipate, rather, the observations made by Lord Collins in Wasser in relation to the approach in various US states as to how damage is to be construed in this sort of policy. Now, my Lord, that's all I was going to invite your attention to in MMI. The critical passages are those that I've underlined, the fundamental character of the period of insurance in a time policy and the requirement that the damage occur during that period. Now, my Lord, that's all I was going to say about MMI for now. If I may, I'll come back to the reference in MMI to knife and face and also the example of the fire in due course. But in my submission, it's better to look at the principle and then to see the context in which the reference to knife and face was given by Lord Justice Hobhouse. So if that's convenient, if I may, I'll then turn to the Wasser, or to Wasser rather, and invite your attention to that, because this that we submit is a case of fundamental importance in the context of time policies and the general principles which apply as a matter of English insurance law. Now, my Lords, you've already, again, had a very helpful introduction from Mr. Edwards. I wonder perhaps if I could just summarise the facts very briefly. It's in tab 44 of the Authorities Bundle, page 1078. And my Lords, as you know, Lexington insured Alcoa under property damage insurance that issued for a 3-year period from the 1st of July 1977 to the 1st of July 1980. and that had a limit of $20 million for loss and damage arising from marine occurrence. Now, two London reinsurers, namely Wasser and AGF, provided reinsurance to Lexington in the same amount for the same 3-year period with a retention of $1.675 million. Alcoa was found liable for the costs of cleaning up contamination caused by waste products which it had generated at 58 different sites across the United States and abroad. And the contamination at each site spread over a number of years, including the 3-year period of cover. What then happened was Alcoa issued proceedings to the state of Washington against its many insurers who provided property damage between the years 1956 and 1985. And it was held in the Washington court that the applicable law in relation to the policy with which we're concerned was the law of Pennsylvania. Now, the Supreme Court of Washington, applying the law of Pennsylvania, held that Lexington was liable in respect of property damage occurring before, during, and after the 3-year policy period, and thereafter Lexington settled the claims for the sum of $103 million US. And Lexington then sought to recover from reinsurers, and it's at that part in the story that this case then starts. The issue for the Supreme Court was whether the English law reinsurance should be construed in line with the Pennsylvania law policy in circumstances where the approach to the period of insurance and damage occurring within it was different in the two jurisdictions. And well, it's quite important to note, we would submit, that it was common ground by the time the case was in the Supreme Court, at least, that if English law applied to the reinsurance, it only provided cover for damage which occurred during the period of insurance. And the Supreme Court held that the reinsurance contracts were governed by English law, and as a matter of English law, reinsurers were only liable in respect of damage occurring during the 3-year policy. Now, I wonder, with that introduction, if I could just show you some of the provisions.
So, strictly speaking, everything that's said on the timing point is actually oversight. Because if it was common ground, then it's...
Well, my lord, it was common ground. There are some, we would submit, pretty definitive statements as a matter of general principle as to English law. And my lord, I rely upon those. Strictly, the position is that I think Mr. Sumption and Mr. Butcher, I'll come out to their submissions in a moment, I think they accepted, the way in which they put it, I think, was to say they accept that perhaps an English court wouldn't have approached it in quite the same way as the court in the Washington court applying Pennsylvania law. But we submit that the statements of principle are general statements of general application of the very highest authority. Now, with that, if I may, can I perhaps invite your attention, please, to page 1089, because this sets out, in the first instance, the provision of the reinsurance slips. It's paragraph 20, towards the bottom of the page. You can see that the cover is for all risks of physical loss or damage, excluding fire allied perils, and or as original. And that, as was held by Lord Mance at paragraph 20, incorporates the terms of the underlying insurance. The period is expressed to be 36 months as of the 1st of July 1977, and the sum insured then 20 million each occurrence. And then please, if you'd be good enough to turn over the page, the remainder of the provisions are set out. And then, if one looks please at the bottom of paragraph 21, Lord Mann says it's unnecessary to consider whether this clause alone would incorporate into the reinsurance all the terms of the insurance. The slip's references to and or as original against the headings form and interest on any view incorporate the relevant insurance provisions relating to the subject matter. Now, on that basis then, I wonder whether perhaps we might just turn to what Lord Mann says about the findings of the Supreme Court of Washington. And if you'd be kind enough to turn to paragraph 29 at page 1093, he sets out the ruling of the Supreme Court of Washington at paragraph 29. And if you'd be good enough, please, to look, first of all, at the first paragraph. He says in the second sentence, the jury found pollution damage to all 3 sites occurred during the entire time the various DIC policies were in effect. And then, because the pollution damage occurred both before and during the various policy periods, a question arose as to how to attribute the remediation cost of the pollution damage. And then a little bit further down, missing from the trial court's analysis is a close examination of the applicable policy language. The insuring clause in the DIC policy states, perils insured, this policy insures against all physical loss of or damage to the insured property, as well as the interruption of business, except as hereinafter excluded or amended. This language is very broad and contains no limitations to the time of the physical loss or damage to property. There is no exclusion in the policy for physical loss or damage that may have begun spreading before the policy inception. The policy definition of occurrence likewise compels a broad reading. The word occurrence shall mean any one loss, disaster or casualty arising out of one event or common cause. There are no words of limitation here. So that was the approach that was adopted in the Washington Supreme Court. And then, please, if you'd be good enough to turn on to page 1095, you'll see that Lord Mansden sets out the effect of that. And paragraph 30, he says, WASO and AGF do not submit that the decision of the Supreme Court on the extent of Lexington's liability under the law of Pennsylvania was perverse or wrong under that law. The purpose of this appeal, they accepted as correct. Its effect was that Lexington was liable for all damage manifesting itself during the 3-year insurance period, although such damage had, in the Supreme Court's words, occurred both before and during that period, or had begun spreading or started before that period. The force of the word manifesting is unclear in the light of the jury's findings. He then records a submission of misassumption, and then goes on at letter E to F. However, its judgment appears to have been read as rendering Lexington liable for all aspects or consequences of any property damage in any area in any site, whenever occurring, any part of which could be said to have occurred during the 3-year insurance period. Now, just pausing there, Sky's case in relation to developing or deteriorating damage is provided that there was some damage during the period of insurance, then the additional damage that occurs thereafter is covered. Now, in our submission, the broad description of the effects of the decision of the Washington Court given by Lord Mance is quite capable of including damage which starts within the period and then, at least on Sky's case, proceeds thereafter. Now, just one point on that to note now, because it's a point that's picked up, I think, by Lord Brown, and we'll come to it in a moment, and it's this. For Sky's case, as I think would be the position in the United States, it wouldn't really matter what the period of insurance is. It could be 6 months or 6 years. As long as damage occurs within that period of insurance, you get the developing damage thereafter. And that was a point that was made by, in the judgments of various members of the House of Lords speeches, I should say, in support of the proposition that that is not the law of England. Now, my Lords, if we could just look to see what was submitted by Council, because it gives at least a little colour to the way in which the law laws proceed. If you could turn first of all, please, to page 181, letter B. You'll see that...
Sorry, just before you leave the passage in paragraph 30.
Yes.
Lord Mance says, however, its judgment appears to have been read.
Yes.
Read by whom?
I think he's talking about how the matter had been treated, well, certainly, I think, in the English proceedings. And I assume that's how it had been read by those who looked at this in the United States. At least that's the basis, that's the understanding upon which the Supreme Court proceeds, at any rate. I did want
Well, except it records a pushback from misassumption.
Yes. Yes.
All right.
But my submission is that the way in which the Supreme Court understand it is the way in which Lord Mance says that that is how it's been read. I don't think that submission is accepted.
I don't understand, while we're on it, I'm not sure I quite understand the end of 31 either. It says the Washington Court acknowledged that its ruling enabled recovery under the insurance in respect of pollution damage occurring both before and during the policy period. I get that.
Yeah.
Instead of identifying whether and how far such damage or the disposal or leakage of waste causing it occurred during the insurance period, it treated all pollution damage manifesting itself or as Mr. Sumption submits, in being at any site during the policy period is covered by the insurance. Whether it occurred before, during, so far so good. And then he says, or it appears after that period.
Yeah.
I don't quite understand that damage occurring after the period could possibly be in being during the policy period. I don't understand how that works.
No. My Lord, the submission was, as you say, the submission that was made was that I think there was an issue as to what
before or during.
Yes.
I understand.
Yes.
But
That's in being during the policy period. Yes.
Your level of damage after.
Yes.
On it, which wouldn't have manifested itself during, by definition, because it wouldn't have occurred until after.
Yeah.
But he just appears to slip that in.
Well, I wonder.
Really, and Lord Collins picks it up.
He does.
I don't quite understand why or how. And
I wonder whether perhaps it is just simply the broad point which is being made, and this certainly is what I'll submit in a moment. But the broad point that's being made here is the primacy of the period of cover. You are, under English law, the indemnity applies for damage that occurs during the period, and in a sense it doesn't really matter whether what you have is damage before or damage which is after. Neither is indemnified under the policy.
I understand what you're going
and it may be that I'm not sure I can do much more by way of peering into the
Washington Supreme Court.
Precisely.
Or indeed Mr. Sumption's, whether that was anything to do with Mr. Sumption.
I'm sure it's something that's far too clever for me to understand, my Lord. But I do wonder whether perhaps it's just simply that it is delineating between some sort of continuum along the lines that has been referred to in MMI and so forth, and the importance of the period of insurance, so that it doesn't matter whether what you're talking about is before or after. It's only that period of insurance that matters. Now, my Lord, can I just take you very briefly to what was submitted? We go, please, just very quickly to 1081 to see what was submitted on behalf of reinsurers.
So sorry, which page?
1081, my Lord. Reinsurers submitted as a matter of English law under an insurance or reinsurance contract providing cover for loss or damage to property on an occurrence basis. The reinsurer will be liable to indemnify the reinsured in respect of loss and damage which occurs within the period of cover, but will not be liable to indemnify the reinsured in respect of loss and damage which occurs either before inception or expiry of the risk. And one of the reasons for inviting your attention to it is just to note the authorities relied upon for that proposition. And one of those we've looked at and another we're about to look at in due course. And then, if you'd be good enough, please, to turn to page 1083. This is where the submissions of Mr. Sumption and Mr. Butcher were set out. And I think perhaps it's enough if I invite your attention to letter F of that page, where you'll see that what is said is the decision on coverage would not necessarily have been arrived at by an English court applying English law. And then the point that was the burden of their submissions, it was never contemplated that the original insurance would come before an English court or English law applied to it. That is peripheral, I think, for our purposes. Now, the case for Lexington depended upon the submission that the reinsurance should be construed according to the law of Pennsylvania, such that damage, as long as it was in existence during the period of insurance, was covered under the reinsurance, regardless of when it occurred, before or after the period. And my Lord, that argument was rejected by every one of the law lords. Now, in terms of the approach that was adopted, every member of the panel agreed with Lord Collins, including Lord Mance, and I'll come to the significance of that in a moment, and Lord Phillips agreed with both Lord Collins.
Sorry, I don't want to be too pernickety, but did you say that it was the... sorry, whose submission did you just recite? Did you just summarise?
The case for Lexington.
Right. And
the insurer.
And you said that Lexington said that it would be covered whether it occurred before or after.
Well, Lexington's submission.
On the basis of the passage we just looked at after, but perhaps.
Lexington's submission was that it was the same scope of cover.
Yeah. as a matter of construction.
It doesn't go any further than that.
I'm just trying to sort of track down who's...
Yeah.
Where after comes from.
Yeah.
I was picking up the reference then. I
understand.
for present
Okay, I
purposes,
won't go down this rabbit hole anymore. Sorry.
No, it's very helpful.
Just bizarre.
It's very
I
helpful.
mean, the submission, we've got it right, the submission really is at 1083G.
Yeah.
Period of reinsurance is the same as the period of the original insurance.
Yeah.
It's no more complicated than that.
Now, when perhaps if we could now just go to please the speech of Lord Phillips to begin with, and if you'd be kind enough please to turn to page 1085. Paragraph 1, he sets out that he agrees with Lord Mace and Lord Collins, and paragraph 2, he says essentially the result of this appeal is dictated by the agreed fact that the reinsurance contract that is the subject of the appeal is governed by English law, and by the well-established principle not challenged in this case that under English law a contract of reinsurance in relation to property is a contract under which the reinsurers insure the property that is the subject of the primary insurance, not simply a contract under which the reinsurers agree to indemnify the insurers in relation to any liability. And then at paragraph 3, Lord Phillips sets out what's common ground. He says that little Roman 2, under English principles of construction, the reinsurance covers only damage to property caused during the period of cover. Little Roman 3, he sets out the position of the Supreme Court of Washington applying Pennsylvania law to the construction of the primary insurance, that it covers incremental damage to property that includes damage that occurred both before and after, so we've got after referred to there again, the period of cover, provided only that part of the damage occurred during the period of cover. And then...
what do you mean by incremental? Does he mean developing?
I think that's developing, yes.
So it would include developing damage occurring after, provided that part of the damage occurred during? Is that how I read that?
I think how the decision of the Washington Supreme Court was understood was that provided that you have some damage within the period of cover, then the damage that had occurred previously as part of the development of the damage and the damage that occurred after was covered as well.
That I sort of understand.
Yeah.
That's just as a matter of logic.
Yeah.
It's not quite what... Anyway, it's not quite what we've seen said in the other parts, but anyway, that's fine.
Well, at least that's certainly how I read it.
Yeah.
And then at paragraph 4, Lord Phillips says this: the last agreed fact is significant. The principle of the English law of construction that confines recovery to damage occurring during the period covered by the policy is no more nor less than the fundamental principle that the words of a contract should normally be given the meaning that they naturally bear. Of course, that takes us back to the first submission I made some time ago. And he again goes on to talk about why it is that the Washington Supreme Court reached the conclusion that it did. Now, with that, I wonder whether perhaps I might then invite your attention to the bottom of page 1086. Lord Walker agreed with Lord Collins, and then please on to the speech of Lord Brown, who also agreed with Lord Collins. And I wonder whether perhaps I could invite your attention next to page 1087, letter G. And there, Lord Brown says, under Pennsylvania law, as already stated, the fact that cover was expressly provided only for 3 years was of no relevance in limiting the extent of recoverable loss, provided only that some physical damage became manifest during the 3-year period. Plainly, however, that is not the position under English law. Under English law, nothing could be clearer than that a contract providing cover for loss and damage occurring only during a 3-year specified period could not be construed as covering in addition damage occurring before, or for that matter, after the 3-year period. And then, Lord, if you can just look at an example that was given at paragraph 15, it's really the point about the period of insurance simply not mattering on this approach. But he says this: for my part, I would reject the argument. Were it correct indeed, it would follow, as Mr. Sumption rightly acknowledged in the course of his submissions, that Lexington would be entitled to recover to the self-same extent as they now claim, even had the reinsurance cover extended not for the coincidence period of 3 years, but say for only 3 months, provided always, as stated, that some damage became manifest during that period. And then, words upon which we rely, given the fundamental importance under English law of the temporal scope of a time policy, I find it impossible that there's no shades of grey or room for reasonable argument about it, I find it impossible to construe the reinsurance contracts in the way contended for. Now, that is the position then at the end of the speech of Lord Brown. Can I now, before coming back to Lord Mance, go to Lord Collins, because Lord Mance agreed with Lord Collins, and it's perhaps as well to take it in that order, if convenient. Would you please then turn to page 1106? And I just wanted to pick up a point I made earlier about Lord Justice Hobhouse anticipating what was said by Lord Collins about the position of the United States. And you'll see at paragraph 57 what Lord Collins says halfway down is this. What is unusual about this case is that the court which imposed the liability on the insurer, the Supreme Court of Washington, applied the law of a state, Pennsylvania, which is one of those states which imposes joint and several liability for the whole cleanup cost in environmental claims on all insurers at risk during the period when the pollution occurred, which may be 50 years or more, provided that some pollution has occurred during the policy period in the relevant policy, in this case 1977 to 1980. And then if you'd be good enough, please, to turn over to the top of the next page, he says it is common ground that under English law, those losses would not be covered by a policy. And then at paragraph 58, he says this, subparagraph 1. In order to establish liability against a reinsurer, the reinsured has to establish that the loss is within the risk assumed under the underlying insurance contract. And then, please, at 5, both the insurance contract and the reinsurance contract were losses occurring during, or occurrence policies as they're known in the United States, which in English law means that an insurer or reinsurer is liable to indemnify the insured or reinsured in respect of loss or damage which occurs during the policy period. And then, if you'd be good enough then to look, please, at 7, the effect of the decision of the Supreme Court of Washington is to impose liability on Lexington under the contract of insurance for loss and damage which occurred both before and after, as well as during the policy period in the reinsurance contract. And 8, it is common ground that under English law, an insurer or reinsurer would not be liable for losses occurring before and after the period. Now, those in our submission are very broad, very definitive statements of principle as to what the position in England is. And it's against that background, then, perhaps, that I can now invite your attention to page 1111. And if you begin enough, please, to look at paragraph 74 at the bottom of that page. What Lord Collins says is this: in English law, where an insurance or reinsurance contract provides cover for loss or damage to property on an occurrence basis, the insurer or reinsurer is liable to indemnify the insured or reinsured in respect of loss and damage which occurs within the period of cover, but will not be liable to indemnify the insured or reinsured in respect of loss and damage which occurs either before inception or after expiry of the risk. And then it's this passage which I would particularly invite your attention to, and why it is that it's referred to. As Lord Campbell, Chief Justice, said in Knight and Faith, the principle of insurance law is that the insurer is liable for a loss actually sustained from a peril insured against during the continuation of the risk. That is the principle that Lord Collins derives from Knight and Faith, and at the end of his speech, and we'll come to it, Lord Mance agrees with Lord Collins, as indeed do the other law lords. And that, therefore, is the authority for which he cites Knight and Faith. In other words, loss occurring during the period of insurance. It's nothing to do...
No, loss actually sustained from a peril insured against during the continuance of the risk, which is the foundation for what Lord Mance says about it, isn't it?
Well, that's something that we're going to come to in a moment.
Yeah.
But yeah, but just taking that language, actually sustained, loss actually sustained from a peril insured against during the continuation of the risk.
Yeah.
That there may well be an ambiguity as to what it is that's is sustained from a peril insured against during the continuation of the risk. Is it the loss or is it the peril? Well,
the point that
peril, isn't it?
it's the peril. It's not. It doesn't say loss sustained during the continuance of the risk.
Well, it doesn't. I accept that. But then perhaps if...
And that's because when we look at Knight and Faith, well, there was no loss sustained after the period of...
Precisely. That is the point with Knight and Faith. And that's what I'll be submitting when we come to look at it. Yes. It's not a case...
It's not a case on our facts at all. It's not a case on our facts at all, Knight and Faith.
Well, it's relied on as in support of the proposition, as I understand it, it's relied on for the proposition that you can have a situation where developing damage which occurs after the period of insurance, is indemnified. The submission I'd be making is that it doesn't provide authority of that proposition at all.
That's not the ratio, but I think it's relied upon because what Lord Campbell says here has been interpreted as meaning that it's the loss from the peril during the policy, not the loss during the policy.
Well, but I understand that, and I understand why it's referred to in that way. I think our submission about that would be this. If you look at the context of this case, there is statement after statement, in the most declarative terms possible, that if what you have is a damage policy, then you can only secure an indemnity in respect of damage occurring during the period of insurance. Now, there would be no reason to cite Knight and Fay at all if it wasn't being regarded as authority for that proposition, and certainly no reason to cite it if it was regarded as an authority which detracted from that proposition. And so I think our submission would be that plainly, when you read the citation in context, it must be being cited for the proposition which is consistent with what's said by all the law lords in WASA, and indeed what I'll be submitting when we come to Knight and Faith in a few moments. Now, Lord, I wonder whether that then perhaps...
Should we just note that Lord Collins went on to say in 74 that he accepted that there may be considerable scope for argument as to what would constitute loss and damage within the policy period, referring to Mace Ltd.
Yes. Yes. Well, look, I was going to come to Bolton a little bit later on, if I may, and quite how the damage is formulated there, because of course that was a liability policy, but we'll come to that, if I may. I wonder then perhaps whether you'd be kind enough to look at paragraph 76, and there Balfour and Beaumont is cited as authority for the proposition that reinsurance on the loss occurring basis, under which a reinsurer is obliged to pay a share of the loss suffered by the reinsured if it occurred during the period when the reinsurance contract was in force. And then, paragraph 77 is the citation of MMI, and Lord Collins refers to the passage from the judgment of Lord Justice Hobhouse, which I've already taken you to, and that says, just before the quotation, at letter F to G, the importance of the period of cover was rightly emphasised by Lord Justice Hobhouse in. Lord, we say that therefore that it, once again, that is a very high authority for the proposition that in a time policy the period of insurance is critical and there is no cover outside it for damage which occurs beyond it. And finally, with Lord Collins, may I just invite your attention to paragraph 111, where he then sets out what would be, that he says, some very uncommercial consequences if the reinsurers had agreed to accept only 2 years of the risk rather than 3, and so forth. And he again refers to the MMI case. And just to finish that paragraph off, he says that Lexington would still be maintaining that in the light of the decision of the Washington Supreme Court, if any damage occurred within the relevant policy period of any duration, the relevant reinsurer would be liable for all of the damage, including damage occurring before inception and after expiry. Now, with that, my Lord, I was going to then invite you to look back again at the speech of Lord Mance, and we've looked at paragraph 30 and what he takes, or what he says, the judgment in Washington has been read as meaning. I wonder then perhaps if I could invite your attention next to paragraph 32, page 1096. Mr. Edwards very helpfully introduced paragraph 32 and mentioned that this was...
Just before you do, did you take us to paragraph 89? This is Lord Collins commenting on the Supreme Court of Washington, I think.
Yes.
In paragraph 89 he says, after referring to the Supreme Court's decision, he said, this was not a decision that losses occurring during the policy period encompassed liability or losses flowing from damage which occurred during that period. It was a decision that provided there was some damage in the policy period, the insurer has a right to indemnity for liability flowing from damage whenever it occurred. Can you just unpack that for me?
well, I'll try. I wonder whether perhaps the distinction is between losses and damage. This was not a decision that losses occurring during the policy period encompass liability or losses flowing from damage which occurred during that period, but rather a decision that provided there was some damage in the policy period, the insured had a right to an indemnity for liability flowing from damage whenever it occurred. Now, the way in which I think we've read that is that what is being suggested, or was suggested in the United States, is that, again, provided you have some damage within the period, then you can recover in respect of damage that occurs outside it. And that the thrust of what's said by Lord Collins in the totality of his speech is that that is not the position as a matter of English law. So with that, I wonder whether perhaps I might then just quickly invite your attention back to page 1096. At paragraph 32, as I've indicated, Lord Mann says that the appeal can, in my judgment, be resolved by reference to certain propositions which are, as such, largely disputed. And then, please, if you'd be good enough to go on to paragraph 38 on page 1089. Lord Mann says, fourthly, it's common ground that if the present reinsurance slip, including such terms of the original insurance as it incorporates, is to be construed according to purely English law principles, it doesn't have a meaning or effect similar to that which the Washington Supreme Court gave to the insurance. The only property damage which the reinsurance construed according to purely English law principles covers is property damage occurring during the 3-year reinsurance period. This is, under English law, clear beyond argument upon its wording. Now, just pausing there, a point that I'll come to in a moment. This wording does not have, in its entirety, it doesn't have any clause of the sort that was postulated by Lord Justice Popplewell yesterday, brackets, for the avoidance of doubt, it doesn't cover damage that appears afterwards. This is a policy that was concerned with damage occurring during a particular period. And what is said by Lord Mance is that the position under English law in relation to such a policy is clear beyond argument. It insures property against risks during a stated period. And then, I think the only passage you were taken to...
So it insures property against risks during the stated period.
So the risk is damage during the stated period.
Yes.
And then he goes on to say what he does in 39, which we're going to come to.
Yeah, and that's what we're going to come on to, which I think is the slightly tricky paragraph, perhaps.
Right, it's for you, yes.
Just teeing it up, really.
If we then come on to paragraph 39, perhaps one needs, first of all, just to look at the introductory words in order to understand what he's citing Knight and Faith for, having regard to the principle for which Lord Collins, with whom he agreed, cited it. This construction of the slip also reflects the basic principle of English property insurance law, that the insurer is liable for loss actually sustained from a period insured against during the continuation of the risk.
That's a typo for peril, isn't it?
It is, yes, yeah. I think we're agreed about that. Now, just pausing there, loss actually sustained from a period insured against during the continuation of the risk. The focus there, we submit, and this is the focus of Knight and Faith, is on the damage that occurs during the period of insurance. Now, the loss, I suspect that you would like me to address, is what then Lord Mann says in parentheses.
But in Knight and Faith, both the risk occurred and the damage was suffered during the period.
Yeah.
During the insurance period. There was no damage sustained after the period of insurance at all. And there was no occurrence of any risk.
But as I understand it, the way in which Sky's submissions proceed is to rely upon Knight and Faith in support of the proposition that developing damage after the date of the period of insurance.
Yeah, but they're in reasonably good company with a number of law lords who seems to have sort of said the same thing over years until somebody's perhaps saying that maybe the Emperor hasn't had any clothes on for a few years.
But my primary submission is that one has to read what's said. First of all, in the light of Knight and Faith, and we'll come to the facts tonight. I know that your Lordship looked at that very closely. But we'll come to those facts. One also has to look at what's being said in the context of everything else that's said in this case. We have 5 law lords advancing the most extraordinarily declarative propositions about fundamental principles of English law, it seems unlikely that Lord Mance is then citing Knight and Faith for a proposition which goes against that. Now, it's fair to say that what he says is, and we can see when we come to Knight and Faith, the text of the judgment, why perhaps he might say it. But he says that in that case, what was focused upon was the need for the peril, the damage materialising or developing from it after the policy period was still covered. Now, as a matter of fact, and we'll come to Knight and Faith, my submission will be that those are not the facts of Knight and Faith. There's nothing in Knight and Faith that suggests that there was any development of damage after the period of insurance. On the contrary, there's a statement at page 1 of the decision which rather points to that. It's not quite definitive, but it points to the contrary at least. But perhaps the broader point is just stepping back, is that whatever else that might mean, it does not mean that as a matter of English law, damage which develops after the period of insurance is somehow to be construed as falling within it and attracting indemnity.
So Lord Mance is wrong in the bit in brackets, is he?
Well, we'll need to come to Knight and Faith just to see how that's expressed.
Yeah, but do you say that he's wrong or not? As a matter of principle, the first sentence beginning, the emphasis in that case was on.
Right.
Is he right or is he wrong?
Well, the question of damage and peril, I think we might just need to look at. What I think I can say is my submission would be that Knight and Faith is not a case where damage materialised or developed after the policy period.
No, that's so far. On my part, I entirely understand that.
I understand.
I think what is said against you about this passage is what Lord Mance was doing was treating what Lord Campbell said as a sound statement of principle and making clear that when he talked about a loss actually sustained from a peril insured during the continuation of the risk, it was the peril that had to occur during the risk, not the damage, because damage materialising or developing from it after the policy period would still be covered. I don't think he was saying those were the facts of Knight and Faith, but that is the principle that he is propounding. Well, I think that's what's said against you in this passage.
Well, again, I think one goes back to the totality of this judgment.
Yeah.
The propositions couldn't be clearer, and they are contrary to and inconsistent with the proposition that developing damage is covered by time.
And it's only Lord Phillips who agrees with this, as well as agreeing with Lord Collins.
Yes.
Yeah.
Otherwise, everybody agrees with
otherwise, you say,
including Lord Mance.
Including Lord Mance.
Yeah. Now, can I also, perhaps this also needs to be seen, I think, as well in the context of what then follows. Because it doesn't stop by citing Knight and Faith. He then cites Lord Justice Hobhouse in the passage that we've looked at, where he's commenting upon the decision of the judge below. The judge came to the surprising conclusion that each reinsurance contract covered liability in respect of physical loss or damage, whether or not it occurred during the period covered. This is a startling proposition, etc. We've seen that. So in the very passage where Knight and Faith is quoted, the proposition of law upon which he's relying by citing MMI is the proposition of law that damage has to occur within the period of cover. And that, we would submit, is consistent with what then follows at paragraph 40. Viewing the reinsurance through purely English eyes can't therefore be construed as a contract to indemnify and occur in respect of all contamination whenever caused or occurring. And in the final sentence of paragraph 40, he says, these represent as fundamental and surprising changes in the ordinary understanding of reinsurance and of a reinsurance period as those to which Lord Justice Hobhouse was referring in MMI. If you'd be good enough then, please, finally, I think, in relation to Lord Mance's speech, just to turn to the top of page 1100, he says that excess of loss reinsurance is underwritten on either a losses occurring or risks attaching basis. In other words, it is fundamental that such a reinsurance will respond in the one case to losses occurring during the reinsurance period, in the other to losses occurring during the period of policies attaching. And, Lord, I think that's all I need to invite your attention to in relation to that. Can I make a short point? Can I give you the reference, first of all? As I understand it, Sky relies upon the Australian decision in Market Form Managing Agency. That you'll find in particular, I think they rely paragraph 46, and so I've got the wrong reference. Tab 53. I'm so sorry. That's very full.
Page 13, 16.
Yes. And if we just go to that very brief, I think all I need to take you to, if I may, is just page 1304, the cover, halfway down the page, the policy relevantly indemnified.
I'm so sorry, where are we? Tab.
Forgive me, it's tab 53, page 1304,
Thank you.
halfway down, the second hole punch. The policy relevantly indemnified the insured for damage that occurred in its entirety during the period of insurance. As I understand Sky's submissions, if the words in its entirety were included in our clause, then their ground one would fail. So the absence of the words in its entirety means, as we understand Sky's case, all the difference. And it's the difference between damage being confined to the period of insurance and developing damage being indemnifiable thereafter. And I think a similar answer was given in the discussion that you had yesterday morning. Now, we submit that that is wrong. As far as we can see, this is the only example that Sky have been able to cite. It's referred to in Colin Verne Merkin. Can I give you the reference for that? It's at tab 80, page 2124. The obvious point to make is that in light of all those dicta that we have looked at, neither the policy in NMI nor WASA included any such wording, and not one member of the Court of Appeal or the House of Lords thought it necessary to make any comment to the effect that, well, it's all a little bit ambiguous. If only those words in its entirety were there, it would be an awful lot clearer. There was nothing to that effect at all. Nothing needs to be added to the words in our policy for the ordinary reader to understand that the only damage which is covered is damage which occurs during the period of insurance. And Lord, it's worth just looking at how extreme the Sky case was, at least at trial. Its case was that it was entitled to recover in respect of the development of damage right up to 2029, when it was contemplated that the remedial works would finish. Now, that's been attenuated for the purpose of the appeal, as I understand it. But either way, we submit that that turns the clause on its head and effectively obliterates the period of insurance.
Well, you say it's extreme. They say that's putting us back in the same position as we would have been in if we hadn't suffered the insured damage. I take your point that that's not what the policy covers.
That's not what the policy
Whether it's extreme or not.
That might be a value judgment I shouldn't have made.
Maybe.
But Lord, I'm grateful. Now, against that background, can I then come to developing damage and to look at the cases which are specifically said to refer to that and relied on in relation to it? And in particular, it's Knight and Faith, and then the references to Knight and Faith in NMI, WASA, and the RENOS. We submit that the effect of Knight and Faith and the RENOS is that provided that the insured event occurs during the period of insurance, the insured is entitled to be indemnified for the full extent of its losses which result from such insured event, even if such losses cannot be fully ascertained or quantified until after the period of insurance. In other words, it's the incurrence of the insured event, in our case damage, which is subject to the temporal limitation, not the ascertainment of the extent of the loss. And in our submission, Knight and Faith and the RENOS, particularly when you look at the RENOS at first instance, which I'm going to invite you to do in a moment, when you look at Knight and Faith and the RENOS, those are cases which are all to do with ascertainment or quantification of a loss, where the issue was whether the vessel in question was rendered a constructive total loss by the casualty, and amongst other things in the case of RENOS, which costs you could take into account, including pre-notice of abandonment costs. But we submit that they're not authority for the proposition for which they're cited. Neither of them is authority for the proposition that under a time policy, when the insured event is the occurrence of damage during the period of insurance, the insured is entitled to recover in respect of all loss and damage, provided that some occurs within the period of insurance. That was the proposition that was rejected in WASA, and English law applied. It was even argued by Lexington. It was common ground. As a matter of English law, that would be wrong. So with that, my lords, could I then invite your attention to Nice and Faith? Now, I know that you spent a little bit of time on that, so I don't want to spend too long on it, but there are just a couple of passages which perhaps I need to take you to. It's tab 1 in the Bond of Authorities, starting at page 5. Now, the Lords, you've been taken to the facts by Mr. Edwards very helpfully. I wonder if I could just pick things up, perhaps 8 or 9 lines down. No notice of abandonment was given. A special case in an action against the underwriters set forth these facts. The vessel received her death blow by the said perils of the seas on the 16th of September, but the damage was not ascertained until the 24th, the policy period having ended on the 23rd. Now, my Lord, we place emphasis on the language of ascertained. Ascertained is a word that's used 7 or 8 times, I think, during the course of this report alone, and we submit that it has the same effect as words that are used in other cases, such as, for example, quantification. And if you take a case such as Chandris and Argo, which I'll come to in the context of looking at what Lord Sumption says of the Renos, as you know, although the issue in the case in Chandris and Argo was limitation, the competing contentions were occurrence of the loss on the one hand, or alternatively the settlement of the average adjustment on the other. The case is all about what had to be done to settle the average adjustment, and that is a quantification exercise. It was not a case about developing damage. Now, just on the point of what the facts of Night and Faith were, if you'd then be kind enough, please, to turn about 7 or 8 lines up from the bottom of the first page of the report. We rely upon this. The vessel received no injury after the 16th of December and remained with her crew on board. Now, it might be said against me, well, that means that there just simply wasn't another event. But it would be extraordinary in a sentence that refers to that if there were any developing damage for that not then to be referred to. And look, we submit that that's the factual foundation for the submission, but that there just was no further damage. And it would be very odd if there were. And I wonder if I could just take you to a passage that, again, that Mr. Edwards very helpfully took you to. And I wonder if I could just start, please, on page 10, just to look at the context in which this arose, because pages 10 to 12, there's a discussion about what was understood to be the effect of a decision said to have been made by Lord Mansfield, referred to in his decision of Mr. Justice Wills, and then picked up by continental legal commentators who disapproved of what they understood those cases to say about what the principle of English law was. And what then happens is Lord Campbell says, well, I doubt whether there ever was such a principle, and that sets out what he says the true position is. So if we just start then, please, at the bottom of page 10, we next have to consider the claim of the plaintiffs for a partial loss. The defendants deny their liability, either for a total or partial loss, relying on meritony. The only account of it is in these words by Mr. Justice Wills, and those words are set out. That was an insurance on a ship for 6 months and 3 days before the expiration of the time she received her death wound, but by pumping was kept afloat. This has been supposed to lay down the rule that where there's a time policy on a ship, if the ship within the time receives damage, however severe, by the perils of the sea, but the amount of it is not ascertained till after the time has expired, until then she's kept afloat as a ship, although from this damage she afterwards sinks or is found to be in a state in which she's not fit for navigation, is incapable of being repaired, the insurers can neither be made liable for a total loss nor partial loss. As supporting such a rule, the decision has been censured by foreign jurists. The learned Benek, who published a valuable treatise on the law of insurance at Hamburg, then sets out what is understood to be the position. And if I could just invite your attention to about 8 or 9 lines down from that, nevertheless, that it is said by Mr. Benek, it is unjust that the insured should receive no compensation for the damage that has happened whilst the insurance lasted. Now, the complaint was that it was supposed to be the case as a matter of English law that even if damage occurred whilst the insurance lasted, in the circumstances set out, no indemnity would be provided. And the purpose of Lord Campbell in then addressing that is to set the record straight and to say, well, that's not actually the position as a matter of English law. And he does that, if you begin enough, please, to turn to page 12 at the top. And what he sets out there at the third line is the doctrine seems contrary to the principle of insurance law that the insurer is liable for a loss actually sustained from a peril insured against during the continuance of the risk. And if a ship insured for a time, during the time she receives damage from the perils of the sea, although the amount of it is not ascertained till the expiration of that time, and she's kept afloat till then, upon the assured taking proper steps by giving notice of abandonment, etc., etc. And then the facts of this case are set out at paragraph 668. And as I think what Justice Snowden has already commented, that there's no reference to further damage. And it's also interesting, just in page 613, there's reference there to a case called Hare and Travis. And the point that's made there is that Pearl Ashes, having been injured by sea damage, both before and after the deviation, but never having been examined until they arrived in London, it was left to the jury to say what the amount of damage they had sustained while protected by the policy. So this is all about Knight and Faith and the other cases to which I'm going to invite your attention in a moment. These are all cases about damage occurring within the period of insurance that the ascertainment or the quantification was after. None of them provides authority for the proposition for which they've been cited by Sky, that developing damage occurring after the period of insurance is covered. And can I just make that good just very quickly? Anderson and Martin is the next case in the bundle. And if we go to that just very briefly, because there's quite a bit of authority to go back to. And if you'd be good enough just to look at the head note there at page 14. In a policy against perils of the sea, the risk insured was only against total loss and warranted free from capture. A neutral ship thus insured during the Russo-Japanese War was captured by the Japanese and while being navigated towards a quarter prize was wrecked and became a total loss. And the issue was whether or not the loss was occasioned by capture or whether the loss having, it said, taken place between the seizure and the pronouncement of the court of prize in Japan, whether the loss could be said to be something other than capture. And if we could pick it up, please, at page 17. That describes the vessel is the Romulus, the German vessel. It describes its journey. Sailed during the currency of this policy for Vladivostok, refers to the Russo-Japanese War. And it says at line 5, in order to avoid Japanese cruisers, the Romulus took circuitous course to the north, was so injured by ice that the master made for Hakodate, a Japanese port for refuge. On the 26th of February, she was stopped by a Japanese cruiser in the Tsugaru Straits, some 30 or 40 miles from Hakodate. A Japanese officer with seamen and marines boarded her, questioned her, and then she was sent to Yokosuka, but then made such water. She altered her course, she went aground, and ultimately she became a total loss as she lay. And it wasn't until the 16th of May that the Japanese Court of Price condemned the ship. Now, there's an example that's given by Lord Lorbin on the next page, at page 18, in order to support the proposition that the loss there was by capture. And he gives the example beginning in the final paragraph. Suppose that the Romulus had been insured against total loss by capture on a time policy that had been taken safe to Yokosuka and there condemned, but that the time policy had expired in the interval between the date of her seizure and the date of her condemnation. In such a case, if the plaintiff's contention is sound, the very thing which the policy was designed to cover would have happened during the currency of the insurers, and yet by reason of lapse of time in bringing her into port and obtaining a decree, that all recourse against underwriters would have been lost. In other words, what has to happen during the currency of the policy is the insured event, in our case damage. Ascertainment is something that can take place later. It doesn't affect the incidence of the indemnity. Now, my Lord, I think we've probably covered what's said about life and faith in Wasser. I wonder whether perhaps I just ought to invite your attention to what's said about it in MMI. It's quite brief. And if you could, well, perhaps I can just tell you what's said there. It's page 390.
Could we look at it? Yes.
Yeah, of course you can. Why don't we do that? It's tab 20. Thank you. And if you turn, please, to page 391. there's reference at the top of the second column to an example of a fire that was considered by Mr. Justice Waller and what would happen if the fire continued over two periods of insurance. Can I address that a little bit later on, after I've taken you through some of the other authorities? But I will come back to that example and what we say about that. But if I could then go, please, to the next paragraph. In this, the judge had overlooked that the problem of dates in relation to time policies is not a new one, covered by Knight and Faith and Anderson and Martin. The loss is attributable to the year in which the loss was caused, not that in which it was capable of quantification. Now, we submit that, again, this is cited in the context of a judgment which is pretty definitive in terms of the need for damage to occur within the policy. We rely upon the language there of capable of quantification and submit that, again, this really is talking about quantification occurring afterwards, not further damage. And more than that, you'll remember I asked you to underline that word arise in relation to the language of the policy. So far as the example is concerned, it might be said that arise is rather broader than occur. That if you have something arising within the period of insurance, it's possible that that could contemplate something that goes on longer. But that's certainly not the case in relation to occur. But my Lord, I just wanted to show you the reference to Knight and Faith and where it's referred to. Now with that, I think I need just quickly to go to the RENOS. Can I, in the interest of time, mention the first instance decision? I would invite you to look at the first instance decision. You'll find it at tab 52. The facts do matter. What happened is that there was a fire on an insured vessel on the 23rd of August 2012, and the damage was significant.
Sorry, we're going to, I'm just still looking at that case. We're going to the RENOS now.
Yes, and I'm just giving you the reference, just in the interest of time. I'll take you to the House of Lords decision, the Supreme Court decision. Can I give you the facts of the first instance decision and invite you to look at it? I don't have time to think through it, but I can make a couple of points.
I'm behind you. What's the
tab 52.
reference? Tab 22.
52.
52, thank you.
Now, the facts, broadly, fire on an insured vessel 23rd of August, significant damage. What then, a lot of the report is taken up by, are a number of surveys and reports that were carried out in relation to that damage. The issue in the case was whether it was a constructive total loss, and we'll come to that when we see the Supreme Court decision. But there are a number of pages in which the judge recites the competing assessments of the damage and indeed the financial consequences. And the very short point that we make about that is that, first of all, there was no issue in relation to an indemnity concerning damage beyond the period of insurance. And there's no reference at all in the first instance decision to there being any damage outside the period of insurance. And given that the case was concerned about conflicting reports relating to ascertainment, it would, we submit, be very surprising if in fact there had been such damage if it weren't referred to. And it's not, and we submit that reflects the fact that there wasn't. And what is held in that, or really what the focus of what is said by Mr. Justice Knowles in that case, the focus is the quantification or the ascertainment of the loss for the purposes of ascertaining whether there was a constructive total loss. And what then happened, the case came to the Supreme Court, and one of the principal issues there was in relation to the ascertainment of whether something was a constructive total loss, whether or not pre-notice of abandonment costs could be taken into account. And what the Supreme Court decided was that they could. Now with that, could we go please to tab 60 and the decision of the Supreme Court in the room. And the judgment starts at page 1496. Now, as I say from the outset, this was not the case where anybody suggested there was continuing or developing damage. That just simply wasn't an issue. And so anything that's said about that, strictly, I think must be overturned. But can I, first of all, invite your attention, please, to paragraph 6 at page 1502. The owner's case on pre-notice expenditure is straightforward. They say that the damage to which the Act refers is the entire damage. So that was their case. And if you just look, please, at letter E, the financial and practical implications of this disagreement are considerable, often impossible to know with any confidence what it would cost to restore the vessel to serviceable condition after a casualty until the damage has been professionally assessed. All about assessment and quantification. Nothing to do with developing damage. And then, please, if you'd be good enough to go to page 1503 and paragraph 10 at the bottom. The starting point for Lord Sumption's analysis in this paragraph uses the word ascertained. The first point to be made is that, as a general rule, the loss under a hull and machinery policy occurs at the time of the casualty and not when the measure of indemnity is ascertained. And then a claim on an insurance policy is a claim for unliquidated damages. The obligation is to hold the assured harmless against insured loss, from which it follows that where the insurance is against physical damage, the insurer is in breach of that obligation as soon as damage occurs. See the fancy. And see also Chandris and Argo. And then he refers to what Mr. Justice McGaw says in Chandris and Argo. Mr. Justice McGaw pointed out the result is that it's not a condition precedent, it's not a fact which must exist and be pleaded, that the plaintiff has quantified the amount of his claim, or even that all the facts exist at the date of the writ, which will enable the proper amount of the claim to be determined. So where there is reference there to facts existing, that's all to do with quantification. It's not developing damage. In other words, facts about developing damage don't yet exist. Nothing to do with that at all. It's everything to do with ascertainment and quantification. And that's reflected in the facts of the first instance decision. And Lord Sumption then goes on to say, these are matters of evidence, not prerequisites of a cause of action. And then he says, the rule that the loss is suffered at the time of the casualty applies notwithstanding that the loss develops thereafter, unless it develops as a result of something that can be regarded as a second casualty. My submission is that Lord Sumption is clearly there talking about the financial consequences developing, not damage, because there was no developing damage on the facts. And that, we submit, is made plain by his reference to Chandris and Argo and what's said by Mr. Justice McGaw about ascertainment and quantification. And it's in that context, we submit, that the reference to Knight and Faith and also the speech of Lord Mounts at paragraph 39 has to be understood. This does not, we say, whatever else it might do, provide authority for the proposition that developing damage is subject to indemnity. Now,
what do you mean by developing loss?
The developing loss is...
As distinct from developing damage?
Oh, the financial consequences. So if you take, for example, at first instance, Mr. Justice Robin Knowles sets out in some detail the various competing reports, which have really quite widely differing assessments as to the financial consequences of the casualty. Yes. And it's that was developing. Similarly, in Chandris and Argo, the question there on limitation was, does it arise as at the date of the loss, or is it when the average is ascertained, which in that case was, I think, more than 6 years after the loss.
But there's a difference, a conceptual difference between ascertaining later the extent of damage during a policy period and developing loss, that is to say, loss which doesn't occur during the policy period, but develops, which is what you say this is about. I don't understand what you mean by that.
The first submission is it's nothing to do with developing damage. It's not that damage got greater, and there's nothing in the first instance judgment on the facts to suggest that it did.
And that's based on the fact that what it does mean is when it says developing loss is something different.
Yes, that's the financial loss.
So what does it mean?
Well, it's the financial loss of developing. The appreciation of those concerned as to what the extent of the loss is develops over time.
No, that's not. So that's not developing loss. That's ascertainment of pre-existing loss. And how would that properly be regarded as developing loss?
Well, it's developing in the sense, as I said, that the appreciation of what the financial consequences are, that develops over time. And my Lord, that's entirely consistent with the references to, in particular, Chandris and Argo, because that's what the case was about.
How then do you explain the reference to, unless it's as a result of something that can be regarded as a second casualty or breaking the chain of causation?
Well,
that must be causing something that breaks the chain of causation of causing some loss, not ascertainment of the loss.
Well, and there could, of course, I suppose, be other losses that might occur over time, such as things such as salvage costs, for example. There may be certain costs attaching to the damage that's already occurred, which are not known until later on. But at all events, whatever else it might be doing, it's not talking about developing damage.
But when you say salvage costs. You there envisage, do you, costs or expenses or further damage which occurs after the insurance period?
Not further damage.
But why not further damage?
No further physical damage to the thing itself.
But why not? If subsequent loss, which is attributable to the insured damage in the form of expenditure, is recoverable, on what basis is that recoverable, but continuing damage, which is attributable to the insured damage, is not recoverable? What's the juridical basis for a distinction between the two?
Well, the submission was that that's not what the position was. That's not what was being addressed. There is no... If one takes the position that the case is addressing the facts of the case and applying principles to the facts, there are no facts indicating that there was any developing damage. And I can only apologise that I've not taken you to the first instance decision. Had time permitted, I would. But that's all about the reports that were being carried out and the assessments that were being carried out over time.
But, I'm perfectly happy to assume you're right about that, but we've got to grapple with what Lord Sumption says, with which all the other members of the Supreme Court agree.
Yes.
And he specifically makes the point that it covers developing loss.
Well, I wonder whether
we've got to try and understand what he means by that.
I wonder whether subsequent paragraphs might help. Could we go, please, to paragraph 13 and then to paragraph 14?
Well, I mean, I have to say, if you go back just to the start of the paragraph, that's on the previous page,
Yeah.
start of paragraph 10, you have the same problem, don't you? As to what he means. He does appear to be talking, undoubtedly, about damage, or loss and damage. It's synonymous, it's got nothing to do with quantification. You know, and hence the point my Lord made to you about something breaking the chain of causation.
Well,
Can I?
And at the end of the day, do you submit that Lord Sumption is wrong, together with the other members of the Supreme Court?
well, if I have to do it, I do. Yes. I mean, my primary submission is that they can be, those authorities, those statements can be read in the context that I've indicated. And my primary submission is that by loss, what he's talking about is financial loss. And I was going to invite your attention to paragraphs 13 and 14 to try to make that good.
Just before you do so, what do you say is the reason that Lord Sumption has included in this the reference to Chandris and Argo and the Fanti establishing that a property insurance claim is a claim for unliquidated damages? What's the significance of that?
I think what's there being done is differentiating between the occurrence of the damage on the one hand, those cases with limitation, and the issue was the occurrence of damage as opposed to something which happened thereafter, quantification, for example, in the case of Chandris and Argo. Now, that's the distinction that's being advanced. Now, when I say, if you ask me to say, is Lord Sumption wrong, I should qualify what I mean by that, in that if what he's doing is citing Knight and Faith or Chandris and Argo for the proposition that you can recover in respect of developing damage, my submission is that those cases don't provide authority for that proposition.
But what he appears to be doing is not only relying on those cases, but prefacing it with the question of principle, that a claim on an insurance policy is a claim for unliquidated damages, and that what then flows from that. And what flows from that, as it's put against you, is the obligation is to hold the assured harmless from the insured loss,
yes,
i.e. breach the moment it's happened in relation to the insured loss. That's the primary contractual obligation. The secondary obligation is then to pay damages for that breach. And damages are the measure of damages, whether you call it quantification or ascertainment, or simply identifying the measure of damages. Normal contractual principles apply: causation, remoteness, mitigation. And developing damage or developing loss or anything that happens afterwards may be, in accordance with the normal measure of damages, the unliquidated damages for the primary breach of obligation. I think that's the case that's put against you, that this is not simply relying on those those cases, but it's a principled development of what the necessary consequences of it being a claim for unliquidated damages, which is how Lord Sumption starts the paragraph.
But it would be flatly contrary to what's said in the WASP about damage having to occur during the period of cover. And it would also, in our submission, state the nature of the promise that's made. The promise that's made is that damage won't occur during the period of insurance.
No, the promise that's made, as it's put against you, is that insured damage won't occur. That is, all right, so that is that damage will not occur during the period of cover.
Yes.
There's a breach of that promise.
Yes.
Then there's a damages claim for breach of that promise. What are the consequences, in accordance with normal contractual principles, in an unliquidated damages claim for insurers being in breach of that obligation?
They are obliged to pay the measure of loss that reflects the damage as at the relevant date, namely the expiry of the period of insurance, and nothing more.
Well, that's not how one applies normal principles of unliquidated damages. You identify the breach, and then you identify what harm has been suffered in accordance with the normal principles of causation, remoteness, and mitigation. One may say, well, that's always subject to the terms of the policy, so it can be excluded and so on. But that then may raise questions as to whether you start with the general principle that developing damage is recoverable, and then you look at the terms of the policy to see if it's sufficiently clearly worded to exclude it, or whether it's enough that the policy says loss is occurring during. But before you get to that stage of subject to the policy terms, I'm not at the moment quite sure what your answer is to the first ground, that simply as a matter of the nature of a property insurance claim, developing loss is capable of being loss suffered as a result of the insurer's breach in failing to prevent insured damage occurring.
No, we would submit that the loss that's suffered as a consequence of the breach of failing to prevent insured damage is simply the cost of putting that right, the ascertainment of the cost of putting that right. The damage that develops thereafter, for whatever reason it might be, whether it is just simply the continuation of that which was there before, which is one of the positions that's put, or whether, in the alternative, it is the inevitable consequence whilst repairs are being contemplated or developed, simply doesn't matter, because none of that falls within the scope of the promise that was made. The promise that was made related only to damage within the period of insurance. And the effect of the sort of approach that your Lordship's just postulating would be to extend the scope of the cover effectively indefinitely, depending on how long the repairs
conceptually,
take place.
it is, I, the insurer, have promised you that you won't suffer this insured damage, and if I've done so, I'm liable in unliquidated damages for the consequences. That's the basic structure. That the unliquidated damages consequences may extend beyond the insured damage.
But within the confines of that clause, the consequences are, by reference to the base of settlement clause, the repair or replacement of the property that's been damaged within the period of insurance. As soon as one then starts contemplating any other damage which extends beyond that, you have gone beyond the scope of the promise, and any damages which might reflect that would not be damages which reflect the breach in question. What places insurers in breach is that damages occurred up to July 2017 and nothing more, because otherwise the scope of cover is expanded arbitrarily by reference to how long it might take a remedial scheme to be designed and implemented, and that could be 5 years, 10 years, why not 100 years?
It's not arbitrarily, it has to be a reasonable scheme.
But suppose, to take the point, suppose a reasonable scheme was 10 years. Suppose it's a very complex piece of property. We would submit that it would be an extremely surprising result indeed if the effect of that was to extend the scope of cover and the scope of insurance liability beyond the period of insurance for another 10 years. In our submission, that would just obliterate the period of insurance and undermine its purpose and efficacy. And going back to the point that was made by Lord Justice Hobhouse, when he talked about the premium that was paid The premium is rated and it's paid according to the defined period of cover, not some unknown period which might extend indefinitely and arbitrarily beyond.
You've got to have damage during the period of insurance. That's what the premium is paid for. Known constat that if you fail to perform your contractual obligation, you're not obliged under normal contractual principles to put the assured back in the same position, subject to causation, mitigation and remoteness, as he would have been in if you'd performed your obligation, i.e. the insured damage hadn't occurred in the first place.
And what you need to do in order to do that is to pay the costs of, in this case, a scheme which represents the correct assessment of the repairs that are required in order to remedy such damage as occurred, but no more, by July 17.
That isn't putting them back in the same position they would have been in if you hadn't been in breach of your warranty in relation to the insured damage occurring at all.
But our submission is that is putting them back in the same position. Anything else is something different. Our promise related only to the damage up to that particular point of time. Whatever else happens thereafter in terms of damage is, we would submit, irrelevant so far as the scope of the promise and the scope of the damages is concerned. My Lord,
I noticed incidentally that Lord Somerset refers back to the one paragraph of Lord Mance's judgment which contains the bit in brackets, rather than all the other ones that you said
he does.
Clear.
He does. But I've already made submissions as to, yes. Well, that's the paragraph, of course, that contains night and faith. So that, I think, is the reason why he refers back to that, because he's relying on night and faith himself, I think.
Well, I mean, the paragraph contains night and faith, municipally mutual, and the words in brackets, of which we've already crossed swords.
We have. But my Lord, I was going to invite your attention. I don't think I've got time to run through it. The proposition that the case is about quantification, not about developing damage, we submit derives support from what's set out at paragraphs 13, paragraph 14.
I'm sorry to slow you up, but
my Lord,
this is obviously important.
It is important.
Lord Somerset also refers to the position as explained by the then editors of Arnold in relation to casualty within the policy period and loss developing after expiry, which is, I think, can only be, can't it, developing damage. Is the same proposition in the current edition of Arnold?
I think it is.
Perhaps somebody could find me the reference.
Well, I think I used it the other day, but I will check it.
If this isn't.
Lord, yes. And
but you say the editors of Arnold are wrong about that as well.
We would say that loss has to be read as financial loss development. That's the submission. And I say
what the current edition of Arnold says is, if a casualty occurs within the policy period and the loss afterwards develops as the result of a sequence of events following in the ordinary course upon the peril insured against, into one which is constructively total, this is as much a claim as one in respect of a casualty whereby a constructive total loss immediately arose.
Well, my Lord, what's being talked about again is the loss, and the loss over time and its ascertainment and quantification. My Lord, we submit that derives support from paragraph 13, and perhaps I should invite your attention to that despite the time. Page 1505. The measure of the damage is its effect on the depreciation of the vessel, represented by the entire cost of recovering or repairing it, cannot make any difference when that cost was incurred. That's the point, and that's what the Renus was concerned with. And one gets the same point from the reference halfway down paragraph 14 to Robertson and Petros, and then the passage that's quoted at letter H. That liability accrues at once the casualty happens, even if the exact position is not ascertained till later. If the assured has rightly given notice of abandonment, the loss dates back retrospectively to the date of the casualty. Again, the submission is that loss refers to the financial loss, not to any developing damage, because there was no such damage on the facts, and therefore there'd be no reason at all for the Supreme Court to be discussing developing damage in relation to a case where there wasn't. It must be the case that what is being discussed is the development of the ascertainment of the loss.
again, and I'll just then, for completeness, read the other sentence of Arnold, which says, where, however, the adverse change in circumstances after the policy has run off is attributable to some new event, which cannot be regarded as a completion of the original casualty. This is a true case of successive losses, and if the first casualty didn't make the vessel a constructive total loss, there is no claim under the policy in respect to the second casualty approximately caused by the perils operating after the policy has expired. Doesn't seem to have much to do with ascertainment. That seems to be a general statement of principle, good or bad, which relates to the happening of the event and the damage which flows in the ordinary course from it.
My Lord, the position with which Lord Sumption is concerned was a case of ascertainment. And my submission is that's what the loss refers to. I think that's probably as far as I can take that. My Lord, I was going to come very briefly to some of the other cases that have been referred to. Reference was made to the Fanti. I don't need to take you through the facts, you know the facts very well. My Lord, really the only point that one gets out of that is that the promise that was made by insurers was to hold Sky harmless against damage during the period of insurance. That's really the only point that arises from that. And the insurers can only be in breach of that promise, even to the extent that that damage occurred. In other words, damage up to the period of insurance. My Lord, the same point really, I think, arises out of the case of Callahan. And again, you were very helpfully, I think, referred to that yesterday. The indemnity in that case was triggered immediately when loss is suffered by the happening of an event insured against. In our case, the event insured against is the happening of damage during the period of insurance. My Lord, you referred to the Starsin case. It's in the bundle both in the Court of Appeal and in the House of Lords. My Lord, the question there was, when did a cause of action for substantial damages arise in tort? And the answer to that question, perhaps unsurprisingly, was as soon as non-negligible damage occurred, with the damage that developed thereafter all relating back to the original cause of action. That was a case about causes of action, and you'll remember you were told by Mr. Edwards that it concerned the transfer of title to goods in transit, and the question was who owned the goods at the point that the damage first occurred. Now, my Lord, in our case, that isn't the question. The question is what damage is covered by the policy, and once again, in our case, insurers are only in breach, even to the extent that damage occurs during the period of insurance. Any other damage is not within the scope of the promise, and it's not within the scope of the breach. My Lord, you were also referred to Bolton and Municipal. I said I'd just come back to that very briefly. My Lord, that was a dispute as to which PI policy responded. The policy on risk at the date of the exposure, or the policy on risk at the date when the tumour first appeared. The policy, just for your note, is set out at page 976, and it was held that it was the latter policy that was on risk because it was only then that there was an injury. My Lord, we submit that simply doesn't take matters further in this case. It's difficult to see how that has any bearing upon a case advanced in relation to developing damage.
Do you take issue with Mr. Edwards' submission that that's an example of a more general principle, that if you have an insurance on bodily injury and you have a tumour and it's on a injury occurring basis, all the disease is treated as when the disease first occurs? Or do you say, well, if you have a cancer that works its way through different parts of the body, as between different policy periods before and after expiry, that the limit of liability would be to as far as the cancer had got before the end of the policy period?
So we would say that well, first of all, the scope of the liability policy is obviously dependent upon what the position is in the underlying law, because the liability attaches to that. And that, we submit, is to be distinguished from the position here, where all the court is concerned with is the construction of a clause which simply says damage occurring during the period of insurance. And to that extent, we say that you don't really get any assistance from Bolton. It's a different sort of case. It's a liability policy, and it's a liability policy as well concerning a particular kind of injury about which your lordship knows there's a vast amount of authority, not least the Fairchild Enclave and so forth.
Yes, but one can have bodily injury policies which aren't liability policies. They're injury policies.
Yes.
dread disease
Yeah.
cover and that sort of thing,
Yeah.
which would be analogous.
Well, it's damage up to the end of the period of insurance.
So if you have a bodily injury which requires surgery, and the surgery takes place after the the expiry of the policy period, what you don't pay for the surgeon making the incision and the like. I mean, how does it work?
Well, perhaps in a case like that, one has to look at whether or not the whole thing is taken together, or what you have. But perhaps one looks at the facts as to how the damage in this case occurred. In a case such as that, you had something happening all together. In a case such as ours, what happens is that you get, and we'll come to this when we look at some of the factual aspects tomorrow, what you have is damage occurring in different cassettes, in different parts of the roof at different times. Those are, we would say, discrete events of damage, whereas they may be distinguishable from the sort of case that you are, or that one's concerned with in a case such as Bolton. We submit that whatever the position is in Bolton, that doesn't affect what the position is in our policy. Our policy is clear by reference to the authority of WASA and others, namely that all that's covered is damage occurring during the course of the policy period. My Lord, I'm not going to spend a long time discussing whether or not insurance law should approximate to tort law. I would just simply remind the court of the warning that Lord Gough gave in Henderson and Merritt in the context of concurrent liability. The court should resist the temptations of arrogance. But as for, I simply don't have time to discuss whether the law of insurance should or should not reflect. So the obvious difference, of course, is that one is the general law, but the other is a matter of agreement negotiated between parties, in this case, very sophisticated parties, to delimit the scope of each other's risk and the allocation of that risk. But, my Lord, apart from that, I simply don't have time to say anything more about it. And then, my Lord, so far as the other authorities that are relied upon are concerned, the COVID business interruption policies, we say, that simply don't help. Those policies have a different purpose, they contain different wordings, and the policy has a different structure of cover. As your lordships all know, that the usual structure is that upon the occurrence of the insured event or the specified cause, for example, the occurrence of a notifiable disease, prevention of access, restrictions imposed by a public authority and so forth, within the period of insurance, then the insured is entitled to recover its business interruption losses as defined up to the maximum indemnity period, even if that extends beyond the period of insurance, because that's simply how those policies work. And that was the position, I think, both in relation to various eateries, and then, so far as Unipol was concerned, as I hesitate to say too much about that case when Mr. Carr appeared in it and Lord Justice Popplewell decided it. But in that case, the issue was whether or not losses fell within the definition of loss occurrence. It wasn't, as far as I could see, a case that was concerned with the period of insurance at all. It was the definition of loss occurrence and which losses fell within it by reference to the hours clause, which I think provided for cover in relation to losses occurring within a 168-hour period. But look, can I just come back briefly to what was said in various eateries? Can I just give you one or two references in the interest of time? The insuring clauses, the references, Bundle of Authorities, tab 76, page 1987. The insuring clauses of 1994. The issue was as to the meaning of the definition of single business interruption loss, and in particular one occurrence. That was addressed at paragraph 27 onwards. From paragraphs 88 to 91, insurers submitted that the effect of during the period of insurance meant that only financial losses suffered during the period of insurance were indemnified. The judge recognised that business interruption losses occurred after the period of insurance could only be recovered if proximately caused. The function of the insuring clause was to identify covered events. That was the thing that had to occur during the period of insurance, and the relevant covered event was the prevention of access or inferred forced closure. Prevention of access or inferred forced closure was such an event. One such event took place in September 2020 within the period of insurance, and on that basis, various eateries were entitled to recover business interruption losses, even if they extended beyond the period of insurance. So in other words, the financial consequences could extend beyond the period of insurance. The insured event had to incur within it, and that's because the situation with our policy is we submit the damage has to occur within the period of insurance. And we'll look very briefly on Unipol. As I say, the policy, the case as far as I can tell, was not concerned with the effect of the period of insurance, but the meaning of loss occurrence. What was it that was required to occur, or what was required to occur within the period of insurance, was the loss occurrence as defined by reference to the hours clause. And loss occurrence was defined as all individual losses arising out of and directly occasioned by one catastrophe. And much of the case is taken up with discussing that. Then, at paragraph 145, the Court of Appeal addressed what they said was the central question. And at 146, what was said was this: an individual loss first occurs when a covered peril strikes or affects the insured premises or property, and when the covered peril which strikes the premises is the loss of the ability to use them, where through damage to other property or through a closure, as in the present instance, the individual loss occurs at the same point. Immaterial for these purposes how the property or premises are affected by what type of peril, the undisputed expert evidence, and I think this is a point that Lord Justice Popplewell was making yesterday, was that market practice was it is to treat BI loss as occurring simultaneously with property damage, and like the judge, I can see no basis for treating non-damage business interruption differently. In all these cases, an individual loss only occurs for the purposes of the hours clause, irrespective of how long the financial loss continues. So in other words, in that case as well, it was concerned with what actually had to occur within the loss occurrence period by reference to the hours clause, not what occurred thereafter. That was the critical thing. But in any event, it wasn't concerned, as I understand it, with the question of the period of insurance. So those are the authorities. I wonder whether perhaps I can then just come very briefly, I said I would, to the fire example that was given by Lord Justice Hobhouse and is referred to in Sky's Skeleton, paragraph 61, Core A, tab 7, page 180. We submit that that isn't a true analogy, that there is, one might think, a difference between an immediate and consuming conflagration contrasted by or with the time lag between the entrance of water and the commencement of decay several months, if not years, later, and that itself variable and patchy, occurring at different times and different places in different cassettes on this 16,000 metre square roof. A fire, one might think, if it's just simply a single blaze at a house, is a continuum in a single action. A better example might be the example given by Lord Justice Popplewell of the bushfire, where you might have separate instances of damage identifiable at different stages. One might be one side of the expiry of a policy, one might be the other. But take perhaps a more straightforward example.
But hang on. If you define the question in that way, as there being separate fires, I can see why you would say, well, the damage caused by one fire started outside the policy period isn't covered. I thought the example was, maybe unrealistic though it is, that the fire starts on the premises because of a spark at 11:30 at night on the eve of expiry of the policy, and it spreads through the remainder of the plot and devours the house at midnight.
Yeah.
Now that, as I understood it, was it's one fire, right, started before, but damage afterwards. And you'd say, tough, your house was not consumed until midnight. Such a shame. Even though the fire on the premises started at 11:30. But
I wonder whether one could approach it this way.
We'll just pay you for reinstating your front garden, which is where the fire started.
Well, my lord, if the policies are damage occurring during the defined period, if the policy expires, let's say, at midnight, then it may. Well, let's take an example where you have quite a large property.
Is that the example that we've actually?
That was the example that's the example I think posited by Sky. Let's take that example. Suppose it is quite a large property. Suppose the fire starts prior to midnight and prior to the expiry of policy 1. And suppose that it's quite a large property, the fire consumes an outbuilding, say. But by midnight, it hasn't consumed the rest of the house. At that point, one can demarcate which damage relates to which policy, relatively straightforward. One can imagine a situation where you have the fire raging continuously. And it might be quite difficult to work out what the situation is as at the interface between one policy and another. It may not be. It may be that one can say, well, by a particular time, the extent of the fire was such that actually, whatever happened thereafter, the house was going to have to be rebuilt. It was lost. It might not be. But, my lord, that's precisely why one has loss adjusters. And the problem that's being identified is not in truth a problem relating to principle. It's a problem relating to ascertainment and quantification. Merely because one has an example such as that, it doesn't mean that you don't give effect to the period of insurance in a time policy. Sure enough, there will be difficult cases. But that is why we submit that professional loss adjusters are retained.
But Lord Justice Hobhouse was simply wrong in MMI.
Well, in MMI...
You say, as a matter of principle, in my Lord's example, you do only get the damage that's occurred.
We would say that you get and of course in MMI, Lord Hobhouse didn't identify the terms of any policy in relation to the example. It was a broad example that was given, I think picked up from the judgment of Mr. Justice Waller,
yes,
in explaining why he considered that judgment to be wrong. But he didn't apply the example to any particular terms, and indeed the policy with which he was concerned in MMI was a policy which referred to damage arising during the policy, not occurring. Now, if I'm pushed, then my submission would be that damage could arise, provided that damage arises in one policy year, that might be sufficient to contemplate damage then continuing thereafter, as long as it starts in that year. But that would be materially different from the policy with which we're concerned, which uses the language of occur. And I've made my submissions as to what that means.
And you may be coming to this. Your answer to Mr. Edwards' point that the subsequent policy wouldn't respond because it wouldn't be a fortuity is what?
Well, my Lord, there may be, I can see, there may be problems in relation to fortuity. But my Lord...
But I thought your answer was going to be, there is no follow-on policy. This is a one-off.
Well, that was going to be my next point, my Lord. Having answered Lord Justice Popplewell's question, I was going to say, so far as this policy is concerned, that simply doesn't arise. As I said at the outset, we're not concerned here with annual policy.
Well, I understand that, but if you're right in this case, it applies equally to to the same wording on a householder's policy, does it, or not?
Well, but Lord, it's perhaps difficult to generalise in terms of householder policies as opposed to a policy such as this. All we're concerned with is a project policy which was designed to cover a specific project for a specific period of time. And my Lord, we submit the effect of the time clauses to do precisely that.
Well, let us assume that the contractors intended to have insurance in place for the period when this policy expired. Wouldn't they be faced with the same fortuity problem under that policy?
Well, the likelihood is that somebody in the position of Sky, after the date on which this policy expired, presumably would then have a subsequent insurance programme encompassing building insurance and so forth. There's no question of having to arrange policies, I think was suggested in one of the examples that was given.
Well, never mind arrangement, but the fortuity problem means it doesn't matter when they're arranged, any insurer in relation to property damage in a subsequent period, which you say isn't covered under this policy, would be going to say not covered under my policy because it's not a fortuity.
Well, my Lord, even if that were the case, that still in this case would not necessarily be an end of the story, because of course Sky has recourse not only to this policy, Sky also has recourse to other remedies under the building contract and so forth. So it's not an end of the position as far as Sky is concerned, even if that were the case in relation to fortuity.
Thank you.
My Lord, with that, I was then, if I may, going to turn to investigation costs. Now, I do apologise for slightly rattling through those.
No, it's not your fault. We've interrupted you a lot.
Well, my Lord, I wonder then if I can turn to those. Now, we submit, first of all, the costs of investigations in order to identify whether there's further indemnifiable damage. That, on the face of it, is not a cost of repairing, reinstating, or replacing property lost or damaged within the meaning of the basis of settlement. Now, my Lord, we submit that the starting point for the consideration of investigation costs is, first of all, the language of the policy, and we've looked at, and your Lordships have seen the insuring clause itself, there are then, as you know, a number of extensions to that policy. Now, my lord, this is a policy that is entered into by sophisticated parties. This is not the same as an ordinary household policy. And my lord, so far as household policies are concerned, your lordship, I think, asked me a question about household building policies this morning. And what I said, and I hoped I said, was that they, I think, are written on a damage occurring basis. But even there, those policies contain extensions for matters such as trace and fire. In other words, all they...
Such as what?
Extensions for tracing, effectively for investigating. There are clauses which are included by way of extension, as opposed to being part of the primary cover. Now, just looking at the difference between a household building policy and a policy such as this, one might expect the cover under a household policy to be rather more generous, on the basis that these commercial parties are very sophisticated parties and are able to negotiate the terms that they consider aptly reflect what they're content with so far as the allocation of risk is concerned. But even in the household buildings policies, and Lord, I say this, we checked an example or two over the short adjournment, even there, household policies would generally include extensions in relation to what really amount to investigations. Now, in this policy, one can see that the cover that's provided is a cover in respect of loss and damage during the period of insurance. There are a number of extensions. And I wonder, please, if I could just invite your attention to core bundle C, just so that we can see how they work. And the extensions are in fact called memoranda. And I wonder whether perhaps you'd be good enough to turn to section 1.
So which page are you at?
I'm so sorry, page 774. Memoranda to section 1, page 774.
77.
Yes. Yep. And you can see, for example, that professional fees are not included within the ordinary scope of cover. They are something which were negotiated as a memorandum to the section. So the insurance in respect of the property insured extends to include an amount for architects, surveyors, consulting engineers, legal or other professional fees of similar nature necessarily incurred in the repair, replacement or reinstatement of such property insured, consequent upon indemnifiable physical loss or damage. So just pausing there, even where you have professional fees which are so closely connected with, and indeed are said to be necessarily incurred in the repair, replacement or reinstatement of such property insured, those do not fall within the primary insuring clause. They only fall for cover as a consequence of the extension. Now, my lord, I'm going to come to another extension in a moment, but what that indicates, we submit, is that what one has to do when construing this policy is one has to look at the overarching context of the policy. One has to look at its purpose, and one has to look at the parties involved. And in particular, when trying to look at what falls within cover or what not, one has to look at the allocation of risk as between the parties. Because that, we submit, is the best indication as to what the parties' intention was and what it was that they thought that they required by way of cover from this policy. Now, it's not simply that professional fees are an extension, which one can readily imagine being involved in repair schemes and so forth, as indeed it says, necessarily incurred.
One would ordinarily think that they are both cost of repair and expended in reasonable mitigation of an unliquidated damages claim. It may be that this is surplusage for the avoidance of doubt, but put in there for the purposes of a limit,
well,
which does apply to this element of the claim. But there we are.
My submission would be that these memoranda, as I understand it, these memoranda are negotiated. These are sophisticated parties. They proceeded on the basis, by definition, that professional fees simply were not included within the scope of the insuring clause. It's for that reason that one has them as part of the memoranda. And my Lord, I wonder whether perhaps I could then also invite your attention a little bit further on at one, that there are a number, first of all, as memoranda to section 1, and then if you go, please, to page 787, you'll see that there are general memoranda. And in relation to that, if you'd be good enough, please, to look at clause 9, you'll see that's a loss minimisation clause. The indemnity under this contract of insurance extends, in other words, not otherwise covered, to include expenditure incurred by or on behalf of the insured as a result of emergency action taken to prevent or minimise physical loss or damage to the property insured, provided that where such expenditure is not approved in advance, the liability of insurers under this memorandum shall not exceed the amount of saving. So even there, an expenditure which is carried out in order to prevent or minimise physical loss or damage is a subject to an extension. Now, just thinking about the Weevil example of Lord Justice Phillips, so far as this policy is concerned, one might have thought that the fumigation of those parts of the consignment that were not themselves damaged, that might well fall within the scope of a clause such as this, because it's not actually, so far as that portion of the consignment is concerned, addressing actual damage here and now. Its purpose is to prevent further damage, and therefore, on the face of it, might fall within a loss minimisation clause. And if that's right, what one gets from that is that that sort of activity doesn't fall within the scope of the insuring clause, the primary cover.
Although both the clauses you've shown us involve limitations, not merely extensions.
Well,
Quotes extensions.
yes, well, just as the word of clause 9, the indemnity under the contract of insurance extends to include, but yes, it ought. Now,
but as a matter of general principle, why wouldn't such costs be treated as reasonable mitigation of damage?
Well, my Lord, it depends, we submit, on the particular policy, the particular circumstances, and indeed the parties. Now, what one is concerned to construe here is this policy, and how this policy indicates what the allocation of risk is between the parties, the allocation which they themselves have agreed as between themselves. And one does that by looking at the scope of the whole policy. And we submit that what these indicate is that they were content that these were not included within the original scope of cover, that that was the basis upon which all were proceeding, that these were to be extra. And my Lord, it makes sense, we submit, in the context of a policy such as this, that investigation costs, on the face of it, do not fall within the scope of cover. And the reason for that, of course, is it's not like the ordinary buildings policy. Here what you have is an enormous construction project with a main contractor and no doubt a number of subcontractors, but at least one subcontractor called Mace. And it may well be that what Sky said to itself was it doesn't need to be covered for the cost of investigation because it's going to have the main contractor and the subcontractor all over the site, all of them investigating the work, not least because all those investigations have to be carried out in order to achieve practical completion.
And they're also insured and are incurring those costs.
Well, my Lord, Sky may well take the view that those members of the supply chain, they would have to carry out all requisite investigations, anything that might be required, in order to comply with the terms of their own building contract. And therefore, Sky just doesn't need to be covered for this. And so, when I was asked the question this morning by Lord Justice Snowden, is there a commercial purpose? Our submission would be, well, yes, you look at it in this context. It may be that in a household policy, one might scratch one's head, although I've indicated that even there, things that might, perhaps from your Lordship's analysis ordinarily, your Lordship might posit fall within the cost of repair, might be treated as extensions. But here, it's really a different matter. And really what one's concerned to do is look at how these parties have allocated the risk of loss and damage between them. And we submit that one gets that from the extensions, and as I say, there's a perfectly good commercial reason why Sky probably did not feel it needed to cover investigations, because it had a whole team of contractors and subcontractors doing just that. And we know and we've seen...
Well, that's Sky, but just focus for the moment on the contractors and subcontractors who are also parties and entitled to such indemnity as the policy provides for their interest. It may not be anything to do with complying with their contracts. This is all risks cover, which may involve a catastrophe that doesn't involve any fault on behalf of anybody in the building project.
Well, one of the facts one might point to, just as a matter of fact, is of course there was a great deal of investigation and drying out work done during 2015-16, and then again we know in 2018-19. At that stage, nobody sought to claim on this policy.
No, leave aside, just to test the principle, that the roof is struck by lightning and some of it gets burnt to some extent. Cost of investigating how much and what to do with it. You say wouldn't be covered but for these extensions.
Well, my Lord, perhaps then I should step back from this policy for a moment, because I think you may well be asking a question which is of more general application.
Yeah.
One of the things I thought it might be, one of the things I then want to do is to come to the facts of this case, because as I think I submitted at the outset, they're quite unusual so far as what's referred to as investigation costs are concerned. And in my submission, quite different in kind from the sort of thing about which we're having a discussion at the moment. But let me come to your Lordship's point. We would submit that if what you have are investigations which reveal that there's no damage at all, that is not covered by this case. If there's no damage, there can't possibly be any cover for investigations which reveal.
Well, then there's no insured event.
Yeah, nice. Now, if, however, it is the case, and if it's the case, that investigations could be considered as part of the costs of repair, that we submit would depend upon the reasonableness of those investigations, and that in itself is going to be fact sensitive and dependent upon the particular circumstances of particular cases.
So is this right? If there is, under any view, an insured event occurs, and the building, the property suffers damage during the relevant period, but you don't know where. I mean, I was trying to think about all sorts of ideas. Is it a big rodent that's somewhere in the building, chewing away, but you just don't know where, right? To find where, you may have to look in lots of places where it is not. Almost by definition, the last place you look will be the place that it is, right? You say you don't get cover for, no matter how reasonable it is, for looking in places where the damage is not. You only get cover for finding it.
Well, I wonder whether the point that your Lordship makes demonstrates the fact that this is indeed fact sensitive. Let's take a situation where you might think that there's damage. You carry out all sorts of investigations.
Well, you know there's damage. You know there's damage. You just don't know where it is.
Right.
Right.
Well, when you say that there's damage, one would have to look at, well, how do you know that there's damage? What's the manifestation of it thus far? And then that would involve questions of likelihood of there being any further damage and the reasonableness of then carrying out any further investigations. At the moment, I'm not entirely sure.
Well, the lights go out because something is chewed through the cable.
Right.
You just don't know where.
Right.
So you've got to try and find it.
Right. But if what's happened is that, let's suppose that you've got one bit of damage where you've got a rodent that has chewed through one tiny bit of cable. Let's say in an enormous building, all the lights have gone out. One could envisage a situation where you would spend a very large sum of money before you actually identify the single bit of damage. In those circumstances, then we would submit it's difficult to see why that should be covered by this policy, a policy that's framed in terms simply of damage occurring. Now, if what you have is a different circumstance, where you've got known damage in a building, a very high probability that there's further damage, and you've got to carry out investigations in order to know the extent of work that needs doing, that might be a different circumstance. But really, this question in my submission needs to be considered on the facts of this case and what it is that's being claimed for. And I'll be submitting, when we come to Yander Newell, that it's a really very different case indeed. You'll remember in Yander Newell, that was the silting up of the estuary at Southampton Docks, just at the mouth of the Itchener. And there was a wildlife sanctuary. The silt was deposited on land belonging to the wildlife sanctuary. The wildlife sanctuary, unsurprisingly, was concerned about the effect that it might have on the wildlife, and they commissioned a report, the result of a survey, in order to find out whether any adverse effects would be felt. Now, as it happened, there weren't going to be any adverse effects, and the question was whether or not those investigations and the cost of the report could be recovered. Now, my Lord, I'll take you to the detail of the case in due course. But all I point out at this stage is what was said in the judgment is, well, by carrying out those investigations, they avoided what otherwise might well have been enormous expense in carrying out wholly unnecessary remedial works. Now, we would submit that the position here is startlingly, really startlingly different, because what is contended for is notwithstanding that there is already a scheme in existence which was prepared in November 2022, costed at £196 million. Nevertheless, further investigation costs, after the trial has taken place, and here we are at appeal, that somehow further investigation costs should be recovered.
But you slipped sort of seamlessly from making what I understood to be a proposition of law, or at least construction of the proposition of law, construction of this contract, to one which is a question of fact.
Well, it's a question of fact.
I'm just trying to understand what actually is. Are you saying as a matter of law it's not recoverable and it doesn't matter how reasonable, or are you actually saying it could be, but just not on the facts of this case?
As I indicated, if you can look at a particular set of factual circumstances, and if it's the case that it could be said that investigations form part of the cost of repair, then in order to test that proposition, it's only reasonable investigations that could be said to form part of the cost of repair, and on that basis fall for indemnity. And my Lord, I do apologise if I didn't make the position clear. It's entirely my fault. The only point I was seeking to draw out of the Yandernur case is that the point made by the Court of Appeal was this was a reasonable course of action for the Wildlife Trust to take because it obviated much greater expense that otherwise might have been incurred. Now, there was another point in that case which was to do with the scope of cover. We'll see that in due course. But here, there is no question of investigations being taken out in order to reduce any scope of repairs. Indeed, as I indicated, the investigations will have no impact at all on the scope of repairs which are the subject of the claim. Those repairs have already been costed at £196 million on the basis of each and every cassette being repaired, irrespective of what the investigation yields, and 9 man days being taken in order to carry out those repairs. All that one might say is that the investigations form part of, or something that will be carried out during the implementation of a pre-existing scheme. And in my submission, that is a world away from the position in Yandernur, and really a world away from, I think, the sort of examples that your lordships have been giving about, well, in order to find out what the damage is and so forth. Well, that might be one situation, but here, regardless of what's yielded, the claim has already been brought for £196 million on the basis that I've suggested. So there's no contingency.
I understand the submission you're making on the facts, but can I just press you a little on the issue of principle and whether it has anything to tell us about whether you're right on your main point?
Yeah.
Cost of investigation can, depending on a fact-sensitive inquiry as to whether they're reasonable, can probably sometimes come within the cost of repair of insured damage, in principle, on appropriate facts, if reasonable. And those costs of investigation are not themselves damage which is covered. So the cost of repair can include expenditure or loss which is not itself directly covered, but is the cost of repairing what is covered.
Insured damage.
Insured damage. So far, so good. Now, if what we're talking about are not investigations, but physical changes to the building, which it's reasonably necessary to undertake in order to carry out the repair, let us say cutting out an entirely sound bit of the external part of the building to get at the bit that needs to be damaged, and then repairing it. Is that within cost of repair?
If what you're doing is breaking into
if reasonable.
If you're breaking into something which is damaged, then again, in my submission, one would have to look at the facts, and that's the trouble with
yes. The facts I'm positing is you've got some internal damage, and it is entirely reasonable and reasonably necessary in order to repair it to cut out a sound section of the external part of the building in order to have access, in order to make the repairs that are necessary. On that hypothesis, comes within cost of repair.
And the basis for that would be that that is repairing or falls within the cost of repair of insured damage.
Right. So one can have damage to the building, in this case deliberately inflicted, which, although not insured damage, can come within the cost of repair clause. Now, what is the difference in principle between deliberately inflicted damage and naturally occurring damage, which is the inevitable development of insured damage, assuming that it's reasonable for both to have occurred?
Well, ex hypothesi, the breaking in order to repair damage, is a cost which is incurred in order to repair that which occurred within the period of insurance.
Yes.
Whatever occurs naturally thereafter is not the cost of repair. What it is additional damage which occurs outside.
Yes,
It's not. I think you're at cross purposes with the example.
Oh, forgive me.
It's damage which is suffered, not insured damage, but damage resulting from the insured damage, in the same way as physically inflicted damage to the building is damage which isn't insured damage, but is a consequence of the insured damage. What's the difference between the two as a matter of principle?
But Lord, I wonder whether the premise is correct to say that it's a consequence of insured damage. It is different damage which occurs as a result of something which precedes both. It's not that the additional damage is a consequence of that damage which is insured. It's a consequence of whatever else might have happened.
You lost me. Well, just say that again.
It's just to say, as I understood the starting point of the question, it was that the damage that occurs outside the period of insurance is, for the purposes of the question, to be assumed to be the consequence of damage that occurs within the period of insurance.
Yes.
And what I was questioning was whether, in fact, that meets the facts. In my submission, it's not the case that if, for example, what one has is a number of timbers in a number of cassettes which might properly be described as damaged at the period of insurance, if what one then has is during the period after the period of insurance, you have different timbers in different cassettes in different parts of the roof damaged, that is not damage which is the result of any antecedent damage.
You're now moving to different facts.
That's not the question. I mean, as I understood it, let's see if I'm okay. The question was this: you take a cassette; it's been damaged during the period of insurance by the ingress of water. Everybody knows that. After the expiry of the period of insurance, let's say 6 months after, by the time everybody's put their heads together, had a cup of coffee, figured out how to deal with it, somebody has to drill a socking great hole through the side of the cassette in order to get at the damage that was caused during the period of insurance.
Yes.
And then after you've dealt with it, like fishing out all the sodden insulation, putting some fresh stuff in that's dry, say, or whatever, you have to cover it up. As I understand it, the question relates to the cost of drilling the big hole and then covering it up. And I thought you would accept, you accepted that either direct cost of putting right after the event and inflicting some more damage on the building to put right that damage which occurred during the period of insurance would be covered.
Yes.
And the question was, okay, if that's covered,
yes,
why isn't the consequential worsening of the inside of the cassette during the same 6 month period that it took you to drill the hole and sort out the insulation also covered? Why, as a matter of principle, is there any difference? One is what you have to do to remedy what was caused, and the other is just the natural worsening of the condition of what was caused during the period.
Well, there are a number of...
If I got the question.
I understand.
It was put rather crisper and rather better, but that was my understanding of it.
My Lord, I'm grateful. There are a number of assumptions built into the question, I think. First of all, is that the damage in question is just, in the expression, getting worse. that I think assumes the sort of damage that occurs after a period of insurance, which might be perhaps captured by the word intensification of what was there. So you might have something which is partially rotten or what have you, but the rot, I don't know, goes deeper in a particular timber or something.
Insulation slumps a
yes.
bit more.
So that's a different case, I think, what's being posited from damage spreading geographically or damage occurring in a different cassette in a different place.
Well,
Now, because that does matter. Because this is not a case where what you have is one piece of damage which gradually worsens over time. The pattern, as you would have seen from the rank maps, the pattern of damage that happens in this case is that you get different pieces of damage in different timbers, in different cassettes, across a 16,000 metre square roof. So, in a sense, the starting point might not be the example that you're asking me to consider, although I'll consider it, but just in terms of the starting point, we'd submit it's not obvious that that is the starting point. And more than that, the proposition that the worsening of the damage is a consequence of the damage within the period of insurance, in my submission, it is not right. It is separate damage, but that is not the consequence of any damage that's gone before. What it might be the consequence of, in your example, is the water getting in. But it's not damage breeding damage. It is a cause which gives rise to different bits of damage or intensifying damage. But either way, the damage that's being described is something that did not occur during the period of insurance, it occurred after, and in my submission is different in kind from damage that you deliberately inflict in order specifically to remedy pre-existing damage within the period of insurance. They're two quite different things. The one, subject to the qualification of reasonableness and circumstance, and I do emphasise that when looking at these sorts of questions, it's not necessarily the best approach simply to look at it in a vacuum, divorced from the facts of a particular case. And in this case, it's vital that one looks at the particular facts because of the, we would say, extremely unusual nature of what are said to be investigation costs. But I'm conscious it's
I'm conscious that we've interrupted all of you quite a lot, but perhaps you rather more than anybody else. And if you want to go on till 4:30, I see from the timetable you'd rather hope to be on to your submissions in favour of your own appeal. If you are feeling a bit battered and would like to retire, that's of course entirely acceptable as well. But if you'd like an extra 10 minutes,
well, that's extremely kind, and I think it would be churlish not to accept your lordship's generosity. So I'd be very grateful for that. It may be, my lords, that I go through some of the other topics at a little bit of a gallop tomorrow. But we apprehended that so far as your lordships were concerned, this was, so far as the various of the grounds that are raised in the appeal, one of the more important ones.
Well, that's certainly how we see it.
Well, I'm very grateful. Now, my lord, as I say, whether or not in circumstances where there is damage, that one might recover investigation costs, that is a matter of, at least in one view, reasonableness, whether they can be said to be part of the full cost of repair. And that will be informed by the facts and what may or may not be reasonable on the facts. And what I was going to do, if I may, was invite your attention to how the judge treated this, really as a starting point. And if you'd be kind enough, please, to turn to the judgment, which I think is in 4B 15. And for this purpose, if you'd be good enough, please, to turn to paragraph 90 at the bottom of page 387. What he said was this. First of all, he pointed out that the need for physical damage to have occurred during the period of insurance impacts on the question whether, as a matter of construction, the cost of investigation is recoverable as part of the full cost. Defendants submit they're not liable to indemnify for the cost of investigations, save insofar as they revealed physical damage, well, you've heard the submissions on that occurred during the period of insurance. The claimants submit that this is wrong, and they're therefore entitled to recover. And it's this section that I was going to invite your attention to in particular. All the costs of opening up each of the cassettes, referred to in this case as lifting the lid, in order to discover whether each has suffered physical damage, irrespective of whether such opening up reveals any physical damage to the cassette being opened up, and incurring the cost of cleaning the internal surface of the cassettes opened up, irrespective of whether the dampness and mould, if any, that was present, would constitute physical damage in the sense set out above. Now, just pausing there, the judge found, as a fact, that mould didn't constitute damage and that was entirely consistent with the evidence that was given by Mr. Coulson on behalf of the claimant, the insurers, whose evidence the judge accepted as being the most probative and upon which he could rely, admittedly, certain to a couple of qualifications, which I'll come to tomorrow. What he then did at paragraph 92 was refer to Jan de Nul, as I have, and he distinguished Jan de Nul. He did so at paragraph 92 by referring to the observation of Lord Justice Sheeman in relation to the definition of property damage in Jan de Nul, and then at paragraph 93 made the observation that it would be unlikely that the policy would cover the cost of investigation in circumstances where access damage in relation to defects is itself not covered. Now, what he then went on to do was to say at paragraph 94 that Sky is limited to recovering the full cost of repairing, reinstating or replacing that part of the property insured that suffered physical damage during the period of insurance. To the extent it has any practical real-world impact on this claim, Mace will be limited in recovering for such costs in respect of physical damage proved to have been suffered down to the date of practical completion. Now, as I've indicated, I'll take this quite quickly. Can I give you the reference for Jan de Nul? It's at tab 28 of the Bond of Authorities. Let me just outline the facts and the basis of the decision, just very quickly. Really, there were 2 points that were taken in relation to this aspect of Jan de Nul, the effect of the SILT in relation to the Wildlife Trust. One of them was to do with the scope of the cover that was provided, which included, amongst other things, financial loss resulting from property damage. And I think it was the case that it was thought that the investigation costs would fall within the ambit of that cover, financial costs consequent upon property damage. And then the purpose of the investigations. And I should probably take you just very briefly to that. If we could go, please, to tab 28. And please, if we go to page 560. If you'd be good enough to look, please, at paragraph 78, just at the bottom. We consider that the dumping of large quantities of silt in the circumstances of the present case did constitute an unreasonable interference with the trust's enjoyment of its land. And then at 79, it's reasonable that JDM that should pay for the cost of the study. If no study had been commissioned by the trust and they'd simply gone ahead at much greater expense to remove the silt, JDM could reasonably have confirmed that no attempt had been made to see whether this was necessary. And then, please, over the page at 561, paragraph 84 contains the insuring clause referring to financial loss resulting from. At page 562, the judge set out in an appendix the relevant provisions of the insurance contract. I don't need to take them to you, but that's where they are. And then, if one looks, please, at paragraph 88, 3 lines up from the bottom, it is manifestly in the interest not only of the insured but also the insurers that where property damage as a result of the insured's activities is reasonably suspected, investigations be undertaken before vastly expensive remedial operations are embarked upon. And my Lord, I've already said that we submit it is a very different case from this. And then paragraph 90, I think, was the paragraph that the judge relied upon. We found this part of the case particularly difficult, and then say it's clear from the definition of the phrase property damage that it's used in a wider sense of its literal one, the trust of third parties, extra contractual liability to whom is in principle covered, and so forth. So that was the passage that the judge cited. Now, my Lord, the insurers pleaded that there was an implied term that the claimants were only entitled to reasonable costs. Sky, I think it's right to say, that paragraph 6.8 of their reply admitted that, but with the qualification of full and reasonable costs. I don't suppose that it's going to be controversial that the claimants are only entitled to reasonable costs in relation to an indemnity under the insurance policy. Now, what then we submit in relation to particular circumstances in this case, and what could and could not be said to be reasonable, is as follows. First of all, I'll be corrected if I'm wrong about this, but certainly this is my recollection. If I am wrong about it, I apologise and withdraw the submission, obviously. But my recollection was that no separate item in relation to the cost of investigation was advanced at the trial. What one had was a schedule setting out £196 million. But I think I'm right in saying, now I'll check this overnight, just to make sure that I wouldn't wish the court to be proceeding on the wrong basis. But I think it's right to say that it wasn't separately identified, and I'm pretty sure that it wasn't spoken to, certainly in terms of amount, by any of the witnesses or experts. But, my Lord, I will check that point.
So when you say a schedule, which one are you talking about? The sort of little one with the manuscript?
No, that was no, I'm thinking in terms of the schedule that was appended to Mace's statement of claim, where there was a summary of costs, but I'm not sure that investigation costs were separately either set out or evidence. Now, instead, to use the language of Yandanur, what the investigation costs comprise is being part of the vastly expensive Mace scheme. They are incorporated within this £196 million scheme. But, as I say, nothing turns upon them, because that is the pleaded claim, and that was what it was that Mace was seeking an indemnity for. And more than that, they're included, notwithstanding that long-running investigations have been carried out to date, at least since 2018, one might say since 2015-16, if one includes the drying out work and inspections that were carried out then, by a variety of different professions. A huge amount of time and money has been spent in devising remedial schemes, and of course the hearing of the trial has already taken place, and the central issue in the trial was the amount of insured damage that had occurred as at the end of the period of insurance. And well, look, it is, we submit, crucial to note that the judge did not reject the Mace scheme because it included lifting the lid. He rejected the Mace scheme because it sought to repair all damage whenever occurring, right down to the date of the trial, and at least at the trial, as late as 2019, not damage which had only occurred during the period of insurance. Now, lifting the lid is itself destructive. It sounds harmless enough. It makes it sound as though you're just taking the top off. But what it really involves is lifting the felt and the OSB of every single cassette, cutting it out, and then investigating that cassette, irrespective of whether, in fact, it has suffered indemnifiable damage, and irrespective of whether Mace's and Sky's own investigations to date have indicated any damage. Lifting the lid, of course, is itself guaranteed to damage the insured property and, to some extent, create a need for repairs to be carried out to every cassette. And as I've mentioned already, consistent with that, it has been costed, and the claim is formulated on the basis that every single cassette, 472 of them, will require repair taking 9 days. And that is wholly independent of the outcome of any of the investigations which are referred to. In other words, it's part of a scheme that's already been prepared and costed, and providing for that work to be done irrespective of the incidence of damage at all. Now, the reason for that is, as I submitted at the very outset of these submissions, that is what Sky was expecting, and that is what Mace perhaps might be obliged to provide under the building contract. But that, we submit, is not a measure of the property indemnity under this policy. Now, my Lord, as I've said, it's strikingly different from the position in the Yandanur. My Lord, in any case, just to make good the submission, that it wasn't because of the investigation costs that the judge rejected the Mace scheme, it was because it simply didn't address damage at 2017. Perhaps I can just invite your attention, please, to paragraph 183 of the judgment.
Sorry, I missed that. 100 and...
183. Well, sorry, perhaps I should start with 182. It's page 420. Quantum. The judge says, well, in many ways, this is the most difficult part of the case. And then line 4, the difficulty that arises is that Sky and Mace schemes assume that all the damage suffered to date and to be suffered hereafter until repair and replacement can be completed should be remedied at the cost of the defendants, whereas I have found or held that this is wrong on a true construction of policy. And then at 183, by the same token, the only attempt to quantify the cost of repairing or replacing that which was damaged down to the end of the period of insurance is the insurer's 2017 and 2018-19 schemes, neither of which it is contended should in fact be carried out. Then the passage that you've been taken to, because the state of the roof is now much worse than it was at the end of the period of insurance and requires more work. The defendants maintain that their liability should be assessed exclusively by reference to the 2017 scheme, but that is wrong as well because it assumes the only damage in respect of which the policy responds is, as Mr. Coulson defined it, which for the reasons set out above is significantly too rejected a definition. And Lord, that's the subject of grounds 1 and 2 of insurer's appeal, and I'll say one or two things about that during the course tomorrow. But then he goes on to say that I am satisfied that of the various schemes discussed in the evidence, the 2018-19 scheme most closely approximates to the work necessary in order to rectify the damage suffered out of the period of insurance. So it's not the case that somehow the investigation cost was a difference between one scheme and another. It was simply that the Mace scheme was fundamentally misdirected at the wrong damage and was approaching matters on the basis of the wrong time. And my Lord, I've probably overrun your very kind indulgence. Would that be a convenient moment?
It would be.
Thank you very much.
Your right of able